It is a single bench matter, Lordship. It was released by the single bench, but as because the DB number was not
We
given,
mentioned. What will we do? Tell us.
Lordship, as because the DB number is not given, that is why the matter is not coming in the list.
So what should we do? Should we list it and give direction? Register Yes, call the list.
Item number 1.
My lord, item number 1, I beg to appear on behalf of the petitioner. My lord, in paragraph number
There is some.
not
to arrest, be arrested.
Huh.
Opposite meaning.
Next.
grateful, my lord.
Item number 2.
Not today.
Item number 3.
Yes. We're dismissing the appeal. All right. Dictation will be- An analysis of the evidence on record would show that the following facts have been proved beyond doubt. Appellant used to suffer from financial stringency. As a result, he would demand money from his father-in-law and torture his wife. His father-in-law was compelled to pay money in installments. Victim had withdrawn herself from the matrimonial home and taken refuge at her parental residence. After Shalish, she returned to the matrimonial home. On the fateful day, members of a local club heard hue and cry from the appellant's house and rushed to the spot. They found the victim, Geeta, lying with head injury. Geeta was taken to Gokshadanga Hospital, where she was declared dead. PM doctor opined death was due to head injury, antemortem in nature. Soon after the incident, appellant was apprehended in the locality and handed over to police. Police seized bloodstained earth and bamboo stick from the courtyard. Appellant took a false plea. He had gone to work on the fateful day, but failed to lead defense evidence to probabilize the same. These incriminating circumstances have been proved beyond doubt and unerringly point to the conclusion that it was none but the appellant who had assaulted his wife on the head and killed her. Prosecution case is proved beyond doubt. Appeal is accordingly dismissed.
Conviction.
Hey, showed up. Yes.
Conviction may be reduced, my lord.
How can we reduce? Tell us.
22.
22.
The lifetime convicted, my lord. Who are, my lord,
Sir, you
62
go.
years
We have
old.
delivered our verdict. Go to the Supreme Court and get it reduced. All right. হ্যাঁ ওটা ডিবি করে এসবি করে Yes, call the list.
Not appear for the petition.
Oh.
My lord, the allegations are under section 22C of the NDPS Act, my lord. My lord,
Yes, how long you are in custody?
my lord, 2 years, 7 months, my lord. My lord, 15.
What is the stage of trial?
Lordship, the stage of trial is date was fixed on 24 January 2025 for PW1, but the witness did not turn up there.
Petitioner is in custody for more than 2 years. He submits there is slow progress in trial. Prosecution witnesses have not been examined as yet. He prays for bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. Though statement, 318 strips containing 8 pieces of plasmoproximon plus capsule each, totaling 2544, and 480 strips, each containing 8 Sampex plus capsules, totaling so and so 3840, were seized from the petition. He is in custody for 2 years and 5 months.
7 months.
For more than 2.5 years. Trial is progressing sluggishly. No prosecution witness has been examined till date. Petitioner is not responsible for the delay. Under such circumstances, petitioner has made out a case for bail on the ground of delay in trial, which infracts his fundamental right under Article 21 of the Constitution. Bail paid on the ground of delay is not fettered by restrictions under 37 of NDPS.
My lord.
Yes.
Oh, actually, sorry.
Yes.
My lord, I am for the petition.
Supreme Court was it.
Yes, next matter.
Item number 8 and 14.
8 and 14. My lord,
I'm appearing for the petition in item 14, my lord. I'm led by Mr. Oyan Bhattacharya, Senate Senior Advocate.
my lord, take copy, my lord, sorry, my lord. এই পেজটা দেন NBMC
So CDR will not provide you with the latitude longitude.
my lord, next page in
And
the in the case diary, the
Huh.
report,
Ah,
the report, they said that my lord, one map is there, my lord. Well, can you see page 192, the Google map, my lord?
hmm.
192.
Sorry.
One is the P.
Ah, 94. Yes. Right. Yes, what do you make of this map? Tell us. Are we investigating or your officer is investigating?
Already
It's
we have
really
raised
such
before the
a
authority.
exercise on our part. An unwilling horse is taken to the pond and made to drink water.
No,
That is our feeling about your investigation. What do you make of this map?
my lord, page
Your
196.
report here is again an evasive one, saying that the latitude longitude is on a real-time basis, so we cannot get it from CDR. We know it.
Yes.
CDR will not give you, the Google drop will give you. So tell us from the Google map where this person's device was.
Not page 196 is the report, man. Page 196.
Have you read it?
Yes.
Tell us. If you have read it, tell us. We don't want to read it. What is this report?
Not,
A useless report?
Report made by the authority.
And who is the authority? Which authority? Your officer in charge of cyber cell is an authority. This is your understanding of electronic evidence. He's only a requisitioning body. The authorities are the service providers. What is the IP address of this device? Authority. We provide training for lawyers on electronic and cyber laws. Please attend them. Ask your ACP, has the ACP any training in cyber evidence? Does he have any training? Did he attend any training on cyber evidence? Then why did he not engage a person connected to cyber cell?
The OC, SOG.
He didn't know. The OCSOG just shirked off his responsibility by giving a report that CDRs do not show the lat long on a real-time basis. He suppressed the fact that that can be got if you give me the IP address of this mobile device. And on the basis of the IP address, I can get it from the Google Maps. Okay. What yes? What yes? This is exactly what we are saying. Every day we are flagging a dead horse and trying to make it drink. And the lives of citizens of this country are hinged on the quality of prosecution as you and the quality of investigation as your ACP. Their liberty, their lives, the lives of victims who are dead, everyone is waiting to improve your performance. See the quality of incompetence you are demonstrating, both as a prosecutor and an investigator. You don't know anything. You only know pages. You have not had any consultation before you come and address us. You didn't feel the necessity to call the OCSOG. And your ACP felt that he got an op report, and that's good enough. End of story. Tell us, we got the medical report. The medical report rules out suicide. The girl was murdered. Now, who murdered? What is the investigation?
The time of death is the girl's death prior to the suicide of the mother.
Very good. So girl's death is before the suicide of the mother. So her suicide note does not reflect the girl's death. Then it is for you to answer these questions. Is the suicide note in her handwriting? Is the suicide note in her handwriting?
Yes, mother. That is already evident in the report, mother.
Where is evident from the report?
Mother, can I get back the case diary? Mother?
I really feel.
Page 105.
At least these people don't even have the pang of conscience.
Well, this is.
Fear of God. Something should trigger that I am wearing a uniform, I am playing a role. Very good. Now, what about the whereabouts of the husband?
Detective complaint.
Naturally. He is the other male member. When this girl is murdered, according to you?
Report murder.
Construct the crime.
Around 12 hours murder on that.
Around 12 hours. That is 12 AM or PM?
Noon PM.
PM. Let us see the postmortem report.
Noon.
And when the suicide takes place? Really? No. This statement does not corroborate to your consider your time of the girl dying at 12 noon. By 11, there was a phone call that the room is closed. What is the construction of the crime? How the crime takes place? Sir, this is not a class going on. This is an exposure of your incompetence and your gross indifference in feeling that you can come so unprepared before a division bench of this court. Okay. And Mr. Public Prosecutor sitting here with your hands folded, as if you are watching your team suffer an innings defeat. Huh? You have no responsibility?
I have already heard each and every point I have this.
Tell us how the murder took place or when the murder took place. Each and every point you have discussed.
My lord,
When the murder took place, tell us. Reconstruct the crime for us and tell us.
I have already informed the.
We are not bothered about whom you have informed. After repeatedly we have told and you were sitting there, it was your responsibility to call all the officers and have a conference before you came and addressed us today. What have you done? You have done nothing. You are completely unprepared. And you have put the blame or put all responsibility on your junior's shoulder. We will record the way in which you are conducting the proceedings here and send it to the legal remembrance.
My lord,
Your employers should
I
know.
have already informed the officer, my lord.
We are
Each and
not.
every point I have.
Yes, tell us if you have discussed each and every point, how the crime took place. Present before us a picture as per the prosecution, how the crime takes place on the basis of materials collected. Tell us.
At the time of, my lord, at the time of suicide or committing.
When the time when the incident occurred. This is not a conference time, is it? Should we withdraw Mr. Aditi Shankar so that you can have a full-fledged conference in our courtroom? We sit in our chambers. When you are ready, we will again hear you. We have fixed it today because we were unhappy tomorrow. All right. Tomorrow we will call the commissioner before us and let the commissioner of police himself see how his officers are investigating and how his cases are represented by the
I
public
have
prosecutor.
also talked with the representative commissioner of police.
No, we will now have the talk with the commissioner himself, not or herself. We don't know who he or she is, but we will have a talk. Since you have talked with the representative, the question is not talking with the representative, Mr. Aditi Shankar Chakraborty. The question is to lead from the front, to see what is the material and how you will represent the case before us. There's a complete disarray in investigation. Your investigating officer does not know how the crime was committed. Your public prosecutor in charge is completely unaware, apart from certain pages which are prompted to his ears by the investigating officer. And you are sitting here.
But I am personally, my lord, apologize, my lord.
No, why should you apologize? We should say you should resign. You don't apologize, Mr. Aditi Shankar. Don't embarrass yourself. Why should you embarrass yourself? You are a competent lawyer. You appear otherwise, but this is an absolute image. It is a very difficult system. You are not able to take the services of your officers, and it is better you relieve yourself from the responsibility.
I'll personally, my lord, satisfy the court, my lord.
We are not concerned about tomorrow. We are not concerned about. We are not at all concerned about tomorrow because we are confident nothing is going to happen.
But I have greatly talked to.
We will, if we fix it tomorrow, we direct the commissioner to be personally present.
My lord, my lord.
That is helping you, my lord. What do you say, my lord? And we will recommend that all right, two things we will direct. We will record our displeasure of the prosecuting officers, that is you and your junior, and we will recommend to the legal remembrancer to consider the issue of appointing more experienced officers in your place. One, and the commissioner of police will be called. Two. These two things we will do. Because we are extremely unhappy. In a case as this, the investigation just is unable to unravel how the crime took place. Two women died under most suspicious circumstances. And till we intervene, your investigating agency, your prosecutors did not even raise a single doubt whether one of them was in all probability not a result of suicidal death. Now, upon our prodding, materials are coming that it is not a suicidal death. What is your answer to the people? You're holding a public post, Mr. Public Prosecutor. You are holding a public post.
Satisfied each and every question, madam.
You will satisfy. The first question is why you were indifferent till today. Why you were indifferent till today? That question you answer. Otherwise, the consequences will follow. We will direct. We cannot remove you because we are not your employer. But at least we will try to shock your employer into action. That if this is the public prosecutor and this is the way in which he supervises the cases, you need to take a look whether more experienced persons should be put into place. We are really unhappy. And we have been repeatedly telling all of you, and you are sitting here, you don't understand that we scale our unhappiness in a graded manner. Because we don't have any grievance against anyone, but we have a very solemn duty to ensure that the processes of administration of justice reach the weak, the powerless, as much as they protect others. So when we see that that is not happening, we have to take steps. If this is the somnolence, if this is the indifference, we are going to take steps. Further report is placed before us. Full stop. In the report, in the said report, the head of the department has clarified that death of Tiyasha Ghosh to Sarkar is not suicidal. She suffered an injury on the head, resulting in death. It is a matter of it is a matter it is a matter of extreme concern and distress till this court intervened. The investigating and prosecuting agency were proceeding on the premise that Tiasha and her mother, what is her name?
Lata.
That both the deceased, that is Tiasha and her mother Lota, had committed suicide. Upon much prodding and stern directions, did the investigating agency, the investigating officer, obtain medical report medical opinion from the head of the department that the death was not, from the head of the Department of Forensic and Toxicology, MBC and H Shiliguri, that Tiasha's death is not suicidal. First report, the second report. When the postmortem examination took place?
Four.
Huh?
Next day.
Yeah. Day,
Four.
time.
Yes, sir, my lord, team take 3:20 PM.
3:20.
3:20 PM.
Hmm.
Tiasha.
So Tiasha and Lota were around 3 PM, both of them. So 18 hours. 18 hours from 3:20.
Lata, my lord, 3.
Yeah,
Lota,
same time. 3 PM. So according to the PM doctor, it is between 18 to 60. And this is 3 PM of
3 PM up to 4:12.
4:12. So 18 hours.
Date what is the problem? Huh? It is what
When the bodies were recovered? Around 11 to 12 in the afternoon of 3rd.
on 3rd. At the time of recovery, my lord, body recovery, my lord, the room has been closed from the uh, inside. And one Jalpaiguri has been seized tool on the tube. Mother died after the death of the daughter, my lord. And mother's strangulation is, my lord, non-continuous. And it is suicidal. Or cause of death of the daughter, my lord, head injury. At the time of committing this, my lord, the defect of complaint, the outside of the
The
house.
the timings of deaths are not matching the circumstances. The mother's timing of death is 12 to 24 hours.
Sorry.
That is why we are saying the opinions not matching the circumstances. If the time of death is 24 hours for the mother, then how can the body of the mother be recovered in the afternoon of 3/12? Right? And
After taking dinner, my lord, they take and thereafter nobody. After taking dinner on second.
so this man leaves the house at 8 a.m. according to him. Who was in the house at that time? Who were in the house?
My lord,
Does he keep the house open? What? Because he says that the wife is sleeping with the daughter.
Right.
So he does not inquire about the wife and his daughter when he leaves the house.
he said, long time the daughter used to study. Does he not disturb his
Please read his statement.
daughter?
Please read his statement. What does he say? On the other hand, he says that he takes medicine, so he sleeps longer. Please read that statement. End of story. People are happy. Land brokers, his wife is dead, his daughter is killed. He is happy, Jody Bhumik is happy, everyone is happy. A police headache is over. If you give anticipatory bail, everyone is happy. Judge has given anticipatory bail.
I'm in custody.
Jody Bhumik gets bail. Or Bhattacharya is happier. He doesn't have to go into jail also. And police is also happy. The judge has given anticipatory bail, so what is the use? No investigation. They died just like that. And now somehow blame the lady. Where is the weapon of offense, Mr. Public Prosecutor? If the lady hit him with something and committed suicide, where is the weapon of offense?
First time it was not seized, my lord. Second time it was seized.
When it was seized,
Second time. The current time was released on 23rd, my lord.
after the anticipatory bail application.
My lord.
So before that, IO is believing it is suicide. How is he believing it to be suicide? He has no sense. A head injury, has he ever in his life, how many murder cases he has investigated? Ask him. Has he ever seen a death by head injury to be suicidal?
আপনার আগে না ওটা আমি বলেছি আপনার
মানে, there is a limit, there is a limit for us to believe fairy tales. We sometimes pray to God that we lose our conscience and our consciousness, so that whatever you thrust under us, we mechanically believe. So tell us, you have read the statement of that man. So what did he say?
He said at the time of incident, he was outside of the house, my lord.
When? Give us the timeline.
Eight.
Before that, what happened?
8 a.m.
What happened to the daughter? What happened to the wife? And he goes out. You say that room is locked.
He thought his wife and daughter is sleeping.
Where? He has never said
Never.
that. So you had a private conversation with him. Then
As per the person of the IO, my lord.
then if he thought his daughter and wife were sleeping, in whose custody did he leave behind the house when he went out? How can he? Just think of it. My wife and daughter are sleeping. It is, room is locked. What I will say? If I go out, I will tell my wife that I am going out. Or I will tell the maid of the house or someone who is residing that I am going out.
Because of the related complaint, actually this house consists of 4 floors. I am living in the second floor. And subsequently, my brother sleep in the first floor. Second ground floor is absolutely in custody of the tenant. So normally, all my family members, my relatives, living in this same building. But there is a division. There we live in third floor. Subsequently, others, my brothers live in second floor, fourth floor. Normally, we in the morning I go early in the morning because I am doing construction work. Regularly visit the plot and giving water to the giving waters to the construction the construction are giving water to that
All right.
particular area. So normally my daughter is studying in the college. She used to regularly study at late night. And that my wife also assisted my daughter also. So normally I know that they will later. Normally I went 8 p.m. Normally I came at 10:30 or 11. At that time the door is locked. Subsequently I call.
We are saying that how many rooms you have on the second floor? How many rooms you have on the second?
There is 2 rooms.
2 rooms on the second, right?
Ah.
One room your daughter and wife is sleeping.
And
One room you sleep. And so when you go out, your room is open. You go out, your room is open.
Yes.
The child of the brother, my lord, they used to play. That's why that will.
Your room is open. You just keep your room open and go.
Yes, because the total building is my relatives, the relatives stay at my house. I normally told them that I am going to the place, my relative, my brothers, they are seeing.
So, Mr. Public Prosecutor, did anyone see him go out that day?
No, as per the any statement, my lord.
Any statement of witnesses that he goes to his construction site? Did you investigate any local investigation in the site? Who are the persons? Whether he went?
Yeah. I saw him, my lord. Can I come?
Then tell your ACP, investigation is not in the office. It is in the field. What is the weapon of offense to which the hard plant substance used?
One tool was recovered, my lord.
Tool was recovered what?
Uh,
Tool is recovered for the lady to commit suicide. Huh? Tool has
But
not been.
time, my lord, as per today's report, my lord, time, mother was died after the death of the daughter. My lord, it, investigation is going on, my lord, maybe mother,
Maybe mother. That's so easy, you know. It's so easy. Dead, don't blame. There is a dead mother. So definitely dead mother killed the dead daughter. IO is happy, PP is happy. And as I said, Ayan Bhattacharya and Joydeep Bhaumik will be happiest. But the problem is, nobody has clarity of truth. Take down. Mr. Bhattacharya, what do you have to say?
My lord, if kindly appreciate two things, my lord. If the daughter was killed by the mother, then why would it will be mentioned in the suicide note that the mother's agony, so that the daughter is taken care of by her brother? Number one. Number two, my lord, in the suicide note, the mention of the earlier death of her daughter was also, my lord, conspicuously absent. Therefore, my lord, the genuineness of the suicide note itself is in question, my lord.
The
And I am
contents
being
of the suicide note does not reflect the true state of affairs.
I'm obliged, my lord. That's the main case I have. Number two, my lord, the suicide note is also within their domain, my lord. How is my custody required with deepest respect, my lord?
This is a case of the facts are not unraveled, Mr.
Absolutely, my lord.
We
302, if
understand.
any, that will be
We
Kwe the
understand.
person, my
We
lord, who was
understand
in the
your
house, my lord.
submission. We understand your submission that the suicide note does not call for serious consideration because the contents do not support the genesis of the incident.
Most obliged, my lord.
The suicide note says that take care of my daughter. Let us see the suicide note.
কাকাকে দায়িত্ব দিয়ে দাও।
Then just Mr. Aditi Shankar Chakraborty.
My version is.
Your
Madam,
version is
madam,
disproved by the suicide note
Madam,
that the mother killed the daughter. If mother killed the daughter by the mother, before committing suicide will say, take care of my daughter.
told, I've each and every point, but I've already
Then-
said, I am not the investigating officer, my lord. This is not my hand, my lord. It is present, my lord. Kindly, my lord. Each and every point, my lord. Each and every, one by one. I have discussed.
And my lord, it was told to the brother, not to the husband,
But
my
there is
lord.
no reflecting, my lord. What
That
can
take
I
care
do,
of my
lord?
daughter. Brother-in-law, to the brother-in-law, not
Each
to the
and
husband.
everything, my lord. Ask him, my lord. He is present before your lordship, my lord. repeatedly, not one time, my lord, on the first occurrence, my lord, when the matter has been firstly moved. Even the previous I also, my lord.
It, what is this? HS of 4S F কাজ করেছে আমার স্বামী কাকিমা বলে মহিলা আমার টাকা নিয়ে হার্ট অপারেশন করেছে। What does that mean?
My lord, I'm explaining this state matter. Actually, the Lata Shanta and the total complex, both are the promoters. And in, there was an agreement, there was one land agreement that that she had purchased a land in one area named as Forest Club, near the Forest Club. And at that time, the petitioner, the person, Roy, has interfered the state matter, claiming huge amount of money. And for that reason, due to a mental trauma, she has committed a suicide.
Yes, what? We didn't follow you. Repeat.
The Lata Sarkar made an agreement. There was one plot nearby one club named as Forest Club. And subsequently, when she made an agreement, in that time, the commissioner interfered in this matter. Mentally created some trauma, threatening her, and due to such
PK, প্রসেনজিৎ PK বলে একজন আছে।
means
Pradeep Chaudhary.
He already arrested, my lord.
You are আছে ও টাকা নিত।
He is FIR, madam, he is already
And
arrested.
I am in custody.
প্রসেনজিৎ কোটি
Pradeep
আমি
টাকাও
Chaudhary.
বেশি নিয়ে,
Pradeep Kumar Chaudhary alias PK. I am in custody.
হ্যাঁ, and প্রসেনজিৎ কোটি টাকাও বেশি নিয়েছে, কয়েক বছর জানে মারার হুমকি দিত। অনেক টাকা। Who is Dulal Bulti?
Kulal is the brother of the defective company.
And Bulti,
And Bulti
Bulti, wife.
is the sister-in-law of the deceased.
No, my lord, what I could gather from the online proceeding, according to the state, my lord, the suicide was preceded by by the murder. If that is so, my lord, then why won't the wife report the incident of murder to someone, my lord, with deepest respect?
Suicide is not preceded by murder. Murder is preceding the suicide.
Murder is preceding the suicide. I'm sorry, my lord.
Murder is
So
preceding
murder,
the suicide.
then suicide.
And the
Right, my lord.
problem is, if the murder is preceding the suicide, then why should the suicide note indicate the victim's concern, as you pointed out? with regard to her daughter who is already dead. And the
Absolutely, my
bodies
lord.
are found inside the room.
Right, my lord.
Bodies are found inside the room. Just see, Mr. Aditi Shankar.
And so far, my complicity is only, my lord, the suicidal note, nothing else. Because admittedly, I'm an outsider. And also in the suicide note, my lord, the brother-in-law was requested to take care of the daughter, not the husband.
What is these two lines at the top? You cannot understand this. What we propose to do is let us release the main photograph from arrest and direct the investigation how it done properly with regard to the death. This is incongruous.
এটা কি লিখেছে? LS 4S মানে কি? ও 4S 4S ক্লাবে কাজ করেছিল।
But the thing is, how do you explain the suicide note saying that the daughter be taken care by your brother when the daughter is dead? And as per medical report, the death of the mother is after the daughter's death. Then was the mother not aware of the daughter's death?
Or my lord, prior to the incident, all the incident, this note was written by the mother.
And then she killed her daughter. Then who killed her daughter? Mother saying that take care of the daughter is not going to kill the daughter. Right? Then who killed the daughter? Who killed the daughter? Right? Husband का भी रोल है. देखो. Suicide. Medical opinion also notes that the daughter had died prior to Tiasha had died prior to her mother. So and so. In this backdrop, so and so. The report also, in this backdrop, we have taken up the consideration of the prayer for pre-arrest bail. Full stop. Mr. Bhattacharya, senior advocate, contents petition was not present at the place of occurrence. He cannot be he is not responsible for the death of the daughter. I know. Responsible for the death, for Tiasha's death. Suicide note ought to be taken with a pinch of salt. In the note, the other victim, that is Lota, while implicating the petitioner, recorded the death, while implicating the petitioner, had also recorded, had requested her brother-in-law and his wife, Dulal and Bulti, to take care of her daughter. It is incongruous. Now, this is incongruous to the state of affairs, which show that her daughter Tiasha had predeceased her, and the bodies were found inside a room closed, were found in a room closed from inside. Full stop. Closed from inside. Accordingly, he prays for pre-arrest bail. Full stop. There are too many imponderables in the case. Prosecution case. The instant case was registered on the basis of complaint lodged by one Shadhon Sarkar, wife of Lota. He alleged the husband of Lota. He alleged he and his wife were involved in construction business. Petitioner and others, his wife had entered into an agreement for purchase of land near a local club. Petitioner and others are land mafia and started threatening his wife with dire consequences. Dire consequences at night, dire consequences with regard to the transaction. His wife had lodged a criminal case earlier against some of them. Good stuff. On the fateful day, that is 3/12/2023, he had left his residence for construction work. His wife and daughter were inside the room, which was in the room locked, which was locked from inside. Subsequently, he came to know that they had subsequently he was informed that his wife and daughter had committed suicide. On the strength of his complaint, investigation commenced. One Prosenjit Chaudhuri.
Prosenjit Chaudhuri is paying for anticipatory, but I am Pradeep Kumar Chaudhuri.
One Pradeep Kumar Chaudhuri was arrested during investigation. Full stop. Petitioner and others, it has applied for anticipatory bail.
Please, my lord. Please, my lord.
Petitioner applied for anticipatory bail. During hearing of the case, this court noted a number of incongruities. And directed Commissioner of Police to transfer investigation to a superior police officer who shall undertake a more intensive investigation, particularly with regard to the following issues. Paragraph 7. Full stop. Investigating officer has submitted reports which have submitted reports which inter alia show which inter alia disclose two vital circumstances. A, death of Tiasha is not suicidal. She had suffered head injury due to head injury from a hard blunt substance. Full stop. 2, Tiasha's death had preceded that of a mother, Lota. Full stop. Statement of investigation with regard to the whereabouts. Now, CDR was produced with regard to the investigation regarding whereabouts of the de facto complainant on that day. Learned counsel for de facto complainant submit. The family used to reside in a joint family property. They occupied the second floor of a three-storied building, of this three-storied building. His client used to sleep in one, the two rooms were in their occupation. One room was occupied, his client used to sleep in one room while the other room was occupied by the petitioner, by Lota and his daughter. On the fateful day, he had left around 8 a.m. to witness to his construction site. Later on, he was informed about their unnatural death. De facto complainant is unable to disclose. However, de facto complainant is unable to enlighten this court why he described why in the first information report he had disclosed that his daughter had also committed suicide. Full stop. This may require further investigation with regard to his role in the crime. It is also significant to note, it is also with regard to his role in the crime. Mr. Bhattacharya, next paragraph. Mr. Bhattacharya strenuously argued the suicide note does not reflect correct state of affairs. It is inexplicable why Lota would entrust the responsibility of her daughter, Tiasha, to other relations and not her husband. It is also argued, now in the event Tiasha had predeceased Lota, how predeceased Lota, issue of entrusting the latter's responsibility to other relations do not arise. These are serious imponderables which would require further and more intense investigation in the circumstances in which the note was penned by one of the deceased, that is Lota. That is Lota. However, forensic opinion establishes that the suicide note is by her own hand. Full stop. In the suicide note, Lota has implicated the petitioner and others in implicated the petitioner and others in subjecting her to continuous harassment and torture over land deals. She blames them for her suicide. These aspects implicate the petitioner. These aspects are supported by other corroborative evidence, including registration of an earlier criminal case against the associates of the petitioner. Associates of the petitioner. It is associates of the petitioner. There are various associates of the petitioner. Investigation in the matter is in progress to clarify various gray areas. However, the penumbral matrix which require further investigative probe do not wash away the incriminating accusation in the suicide note against petitioner and Prosenjit
Pradeep Kumar Chaudhary.
and Pradeep Kumar Chaudhary with regard to the harassment and torture upon Lata, which resulted in her suicide, which compelled her to commit suicide. The attending imponderables regarding the facts and circumstances of the unfortunate and presumably homicidal death of her daughter would require further investigation, including the role of the petitioners, in such view of the matter and the gravity of the offense involving homicidal death of Tiasha and suicidal death of Lata. We are of the considered view this is not a fit case to grant anticipatory bail. Application is rejected. We must follow this order with a we are constrained to follow this order with a postscript. Rejection of pre-arrest bail does not we must follow this order with a postscript. This court experienced serious indifference, noted serious indifference and a callous attitude of the investigating officer in conducting investigation in a rare case where the unnatural death of two women who কি বললাম in a serious case where two women appear to have suffered unnatural death in the backdrop of fight between land in the backdrop of fight with land mafia. Full stop. Land mafia. Full stop. In fact, death of one of them, Tiasha, was glossed over as suicide till this court corrective directions were given by this court. This persuades us to hold that that a fair and impartial investigation would require continuous monitoring by a constitutional court so that truth is revealed and so that the continuous monitor so that to ensure proper investigation. Full stop. Proper investigation. Investigation would also investigation into the crime may also require investigation into the crime may also require analysis of electronic data, which upon interrogation of the investigating officer. Now, who investigating of electronic data? Full stop. Interrogation while interacting with the investigating officer, we noted his lack of competence in that area. Commissioner of Police is directed to constitute a special investigation team which shall be presided by himself and would comprise of specialized officers in tracking cyber evidence, tracking electronic evidence, the electronic evidence. The Commissioner of Police shall submit report before this court on a fortnightly basis with regard to the progress of investigation. Full stop. Matter is adjourned for a fortnight.
My lord, one indulgence in respect of the 439 matters, I am in custody.
Rejected. Rejected. ওই দুটো একসাথে নিয়ে রিজেক্টেড হ্যাঁ We'll come back after 5 minutes.
Section 85, 109, 351 of the BNSS Act, Miller, 44 days in custody, Miller.
We have considered the
Miller,
materials.
15 years of marriage, Miller.
We
Miller,
have
kindly see the
considered-
statement of the Miller, the son of the Miller, dispute between the son of the Miller, de facto
My lord,
complaint.
the son
Miller.
is, was present at the time of occurrence. My lord, the son saw that.
Is she out of hospital?
Yes, my lord.
Miller, we have taken to hospital. Miller, kindly see the statement of the
We have
Miller.
a petitioner is in
Miller,
custody for 45 days.
44 days. Miller.
44 days. We
We
have
have taken her-
considered the medical papers. Victim lady is
Miller,
presently out of hospital.
we have taken hospital, Miller.
Uh,
kindly-
Keeping in mind the facts and circumstances of the case, we are of the opinion further detention is not necessary and petitioner may be granted bail.
Grateful.
And share. Of indication they may. Next.
Well, allegation under say 341, 323, 324, 307, 506, 34 of the Indian Penal Code, Miller. I'm in custody 72 days, Miller. Investigation complete, charge sheet has been filed, Miller.
We have considered materials on record. Petitioner is in custody for 72 days. Though injury are grievous, whether the injuries are life-threatening may be considered at the appropriate stage of the proceeding. Balancing the nature of accusation with the period of detention suffered, we are inclined to grant bail.
Grateful, Lord.
How is your father?
Now he's fine.
Now he's fine.
Well, yesterday they have served the copy on us, so
So
one
what
day,
will we
tomorrow,
do?
my lord.
What will we do? Bring the injury report. How long you are in custody?
67 days.
Tomorrow.
Tomorrow.
Next.
Yeah, man.
Victim notified.
Yeah, Lordship, notified, Lordships. Lordships, there is a 2164 statement of the two
Atrocities Act.
Hmm.
Lordship, during pendency of the application,
Hmm.
there is some development and which I have brought through supplementary affidavit. Now, in page number 13,
The application is not maintainable.
Lordship,
Yes,
if prima facie case is not made out,
Ah.
Lordship, in
Yes.
that case, court can consider.
Right. So prima facie case is made out.
No, Lordship, the thing is that here, they are in the FIR, there is an allegation of dispossession.
Hmm.
But the FIR was lodged on 11th of the month. And when the incident took place on 7th, there's a delay of almost 4 days.
Ah.
In the meantime, on 9th, they have filed one civil application.
That is the credibility of the allegation.
Lordship. And
We are not to look into credibility of the allegation.
Lordship,
We are to look into the issue whether you had knowledge that these persons were members of the
SCST community.
scheduled tribe and
Lordship.
caste, and you forcibly
Lordship,
erected a gate.
Before that, Lordship, we were enjoying an injunction order from the civil court.
Hmm.
And civil court says that that's why, Lordship, I'm trying to apprise this court with page number 13 of the supplementary affidavit, Lordship. Please go through it once, Lordship. Especially page number 17, Lordship.
These are malafides. They do not go into the jurisdiction of anticipatory bail.
Lordship.
You can file an application under 482,
Lordship.
but not anticipatory.
Lordship, let me explain, Lordship. In this matter, Lordship, if we go through the plaint, which is in page number 17,
Hmm.
what they have said that the plaint was filed on 9th and this FIR was filed on 11th.
Hmm.
The plaint does not say what is there in the FIR, Lordship.
Sir, the FIR speaks of an incident of 7th.
7th, Lordship.
And they say 7th, you dispossess them, file the plaint,
Lord,
saying that you are in
filed the
possession.
plaint on 9th, Lordship.
That's
And
exactly
9
what they are
does not
saying.
say when they have filed the plaint on 9, they are not saying that we have dispossessed them, Lordship. That is my point only, Lordship.
Who has filed the plaint?
Rebecca Subba, the de facto complaint. That's why I'm trying to apprise this court, Lordship. Page number 17 of my supplementary affidavit. Page number 13 is the one. Page number 17, paragraph number 14, Lordship. Go through it once, Lordship. It will disclose everything. There is no question of dispossession, Lordship. They are admitting that we are enjoying an injunction order.
They have blocked the entry and exit permanently.
That is my only contention, Lordship. Nowhere they have said that I have made a wall or something like that. Also, delay has not been explained, Lordship. There is an afterthought, Lordship. The FIR is an afterthought.
Very clear. 14.
I have annexed my plaint also, Lordship, which I am enjoying an injunction order. And that says I am.
Yes, now tell us where is the gate constructed?
On his land, on the land of the de facto complaint.
Land of
Entry and exit.
all right, take
I
down.
was here, I have a videograph also.
Petitioner contents. Petitioners are the directors of.
No, Lordship, I am an employee, Lordship.
Petitioner is an employee of a construction of a development company. He contends that the is an employee of Messrs. Jain Group Products Private Limited, a development company. He contends that the company had filed a suit against the de facto complainant and had obtained an order of injunction in respect of the property of the suit property. In retaliation, the present in retaliation, the de facto complainant filed a suit against the company, and in the suit there is no allegation that the that the company and or its employees had trespassed into the petitioners into the de facto complainant's land,
Or made any gate.
or trespassed or constructed any gate thereon. Full stop. The allegations are out and out false, and the ingredients of the offenses under SCST Act, they are not disclosed. In opposition, learned lawyer for state as well as de facto complainant content, de facto content that the de facto complainant is a member of the scheduled caste community. Petitioner and others had illegally trespassed on their land and had constructed a gate. This compelled the petitioner, this compelled the de facto complainant to lodge first information. We have considered the materials on record. FIR has been registered inter alia under section
3 and 4.
3,
3, 1,
3, 1,
1, 4 and 5. 4 and
3, 1, Roman 4, 5 of Act of 89. Section 18/18A of the Act of 89 bars entertainment, bars a prayer for anticipatory bail in such cases. In Scadia, the apex court clarified that it is open to the court that the bar ought not to be mechanically applied, but the court would look into the allegations in the first information report first information report and materials collected during investigation to come to a finding with regard to prima facie case. Prima facie case would undoubtedly satisfaction in respect of existence of prima facie case would be based on the allegations in the first information report. In allegations of malafides, however, would not justify entertainment of an application for pre-arrest bail. We have examined the allegations in the first information report from the aforesaid legal prism. Uncontroverted, in the first information report, it is unequivocally stated that the petitioner and others had trespassed into the de facto complainant's land and erected a gate. Credibility of the allegation, learned counsel challenges the credibility of the allegation on the score that erection of the gate, illegal erection of gate, impacting egress and ingress to de facto complainant's land is not pleaded in the prior civil suit. Noting the averments in paragraph 14 and 15 of the plaint, it appears that it is clear the de facto complainant alleged interference and disturbance to possession as well as egress and ingress. Possession as well as ingress. As well as egress and ingress. It cannot be said that there is no averment with regard to the aforesaid foundational facts in the plaint itself, in the plaint instituted by the de facto
They
complaint.
have also not prayed for recovery of possession. That
Very
means
good. All these things in suit. Prima facie case. All right.
This is a case of dispossession, Lordship.
We are looking
They
into
are
a
not saying that they have been dispossessed.
Don't,
We are
does
saying
not
that-
require a disturbance of possession is good enough.
But section is saying that they has to be dispossessed, Lordship.
Oh, if you build a gate and you don't allow egress and ingress, that's not dispossession.
So they will file for recovery of possession in that case.
Oh, they will file for recovery of possession. They are well advised. But whether a criminal case can be filed or not, that's our concern.
They are saying that they are in possession in the plaint, Lordship.
They have never said they are disturbing. They
Disturbing,
have
Lordship.
said very good.
Disturbing will not.
We have also satisfied ourselves on the strength of evidence collected during investigation, that is videography of the spot which shows illegal construction made on the de facto complainant's land. In light of the aforesaid incriminating materials, we are of the opinion the application for anticipatory bail is not maintainable. Incriminating materials showing prima facie disclosing offences under the Act of 89, we are of the opinion application for anticipatory bail is not maintainable and the same is accordingly dismissed. Next.
Item 16, Mr. Kumar Santu is for the appeal.
What possible? What is there?
Bail in connection with appeal of NDPS.
All right. What is the amount of recovery? How long he is in custody?
440 days.
How long he is in custody?
And the judgment was produced around a year back.
Right, but was he on bail earlier? Huh?
Just check.
We have
No, he was on
considered.
bail.
We have considered the. We have considered the evidence on record. PW 2, 5 and 7, official witnesses proved the recovery.
436.
Proved recovery of 436.
0.007, if I am not wrong. 0.400. 436.400. What should we find at page 3 of the complaint?
46.400 kgs of ganja. Kept in 28 sacks in a room. Appellants were present in the room. Good stuff. Independent witnesses also proved the recovery, admitted the recovery, but could not identify the appellants. Good stuff. In chain of custody has also been established, and evidence with regard to certification of the seized contraband, including samples, were also produced in court. In light of the aforesaid evidence on record and restrictions under 37 of NDPS Act, we are not inclined to suspend the sentence. Paper book be prepared within 8 weeks of receipt of TCR. Next. Here enough to refer to as act of it. Next.
Lordship, this is an admission of appeal. There's a delay of 156 days.
156 days.
Lordship, I
Appear?
have also served the copy on the
Yes.
public prosecutor.
Who is appearing? You appear? Mr. So-and-so is requested to appear on behalf of the state. Copy is handed over to him. We have considered the averments in the application for condonation of delay being satisfied. Appeal, delay is condoned. This is acquittal.
Lordship, against acquittal.
Oh, sorry. Then you serve the opposite parties.
Lordship, I will do.
All right. For state.
I have
state
already
copy?
supplied.
Who is appearing for state then? All right, copy of the
That's not the-
application is
yes, yes.
served upon opposite party now, 1 to 6, 1 to 8 through register speed post with acknowledgement due. Matter will appear 4 weeks hence.
Great.
Next.
For the state lordships. And yesterday lordships asked the ACB to give explanation why he added a section 17A prayer.
Yes.
And lordships, in writing, they have stated that earlier occasions, same things happened, did not get any permission. That's why the bail was granted 438. That's why he asked for.
That is why we are saying, has he read section 17A? Is there any scope for a
Yes, lordships. There is no
opinion?
scope.
Explanation is placed on record.
May I submit?
Yes, what do you suppose?
No, not on that. My instruction is that to withdraw the application.
Not pressed.
Great.
Explanation is placed on record. We are not satisfied with the explanation. Report, investigation report shows that the key ADSR, na?
ADS.
The ADSR had in breach of rules, relevant rules, extended unfair advantage by permitting registration in the name of a dead person. In light of the aforesaid accusation, in light of the nature of accusation, it cannot be said that the subject matter of investigation relates to any recommendation or inverted comma, recommendation or policy decision of a public servant which would require sanction under 17 capital A of Prevention of Corruption Act. Investigating agency misdirected itself in seeking such sanction. No such sanction is necessary, and investigation, including custodial interrogation of public servants, if any, may be undertaken. At this stage, petitioners do not wish to press the application for TRS bail.
No, it's big. We are in custody.
Application for bail, we are not, accordingly, the application is dismissed. Taragedao, these issues had not been addressed by the coordinate. These legal issues were neither argued nor addressed by the coordinate bench, which granted bail to co-accused. In this backdrop, petitioner seeks to withdraw the bail application. The bail application is dismissed as withdrawn.
Great.
Investigating agency shall forthwith proceed with the investigation of the case without resort to section 17A of the Prevention of Corruption.
Lord, sorry to interrupt in between, my lord. Item number 16, my lord, has pleased to pass an order. I was on leg before.
Yes, now
my
you
lord.
argue.
My lord.
Argue.
Well, but
you don't bother. You argue.
my lord. My lord, since there was a change of brief, my lord, I don't have the copy of the CRA. Only the grant application was handed over to me, my lord.
You argue.
Yes, my lord.
How long are you in custody?
My lord, since
You were on bail. during-
2022. Yes, my lord. In between, I was on bail, my lord.
Good.
These are the bail orders, my lord. I was granted bail by the trial judge, my lord, on the ground that since there was no compliance of 41B as well as, my lord, non-compliance of section 50 and, my lord, 52, my lord. On that ground, my lord, my bail was, I was granted, my lord. Now, my lord, if comes to the, since I don't have the copies of the deposition, my lord, I'm just placing the number of the PW on list. First, my lord, is PW, the independent witness, my lord.
They did not identify you.
No, my lord. They stated that the signature was obtained on a blank paper.
They did not support, they did not identify you, but they said that there was recovery from the house.
No, my lord. That also they didn't say.
All
Because
very,
their signature was obtained.
very good. They did
on a
not
blank
support.
paper.
We'll go
The first,
one step ahead. They did not support.
yes, my lord. This is the statement of the first witness, my lord,
Very
independent
good.
witness.
Next,
Second witness, my lord, he was on in the bazaar.
we have said independent witnesses did not support prosecution case. Now, next point.
Next point, my lord, the gazetted officer was the part of the raiding team, my lord.
Okay, okay, very good. That's will actually turn out against you. Any other point?
My lord, the information, the NCB came from Kolkata to Kuch Bihar on the basis of some information. So that information could not be produced. That as per the NPS, my lord, it has to be diarized, and thereafter the team leaves. That's daddy was not produced or could not be produced before
That
the
is
trial.
non-compliance of 42.2.
My lord.
42.1 and 42.2.
These
This
were
is the points.
My lord.
All right. Take down. Appellant contents. There were there were infractions of mandatory provisions of section 42 and 50 of NDPS Act with regard to seizure and recovery, with regard to search and recovery.
My lord, one more indulgence, my lord. Sorry, my lord. My lord, since I've not gone through the deposition, I could not go through the depositions and the entire record, my lord. So that should also be recorded, my lord. My this submission.
Tomorrow.
Because I have already applied for the certified copy.
Tomorrow.
And they endorse that.
Mr. Counsel, tomorrow.
My lord.
Tomorrow.
Tomorrow.
Yes.
My lord, they have
Mr. Counsel, if without applying for certified copy, you dare to file a suspension of sentence.
No, my lord, it is change of brief, my lord.
We are not bothered.
I've
Don't
already
press the
applied.
application.
They have written.
Don't press the application then.
My lord,
Don't press the application. You can't blow hot and cold.
my lord,
If you are not prepared, don't press the application. We will direct preparation of paper books. All right.
my lord,
If you are prepared, we'll give you 1 day time. Whatever you want. But you cannot blow hot and cold.
my lord, kindly hear me out. If
We have heard you out. We are
kindly,
responding to you.
If the department is directed to hand over the certificate copy,
Nothing. We will not do anything of that sort.
kindly,
We are not concerned whether you got the certified copy or not. We will get the certified copy ourselves on the receipt of trial court records. We'll get the paper book prepared and hear the appeal on merits. Correct. You want a suspension, get yourself ready and do it.
my lord, allow me to withdraw this application because
After arguing for some time, learned counsel seeks to withdraw the application for suspension of sentence. Paper book TCR be placed before this court within 1 week. Paper books be prepared within 4 weeks thereof. Registrar shall communicate this order to the trial court. We'll get your paper book ready by 1 week, within 1 month.
my lord.
So that you cannot take the advantage of change of bench. Yes, Are these two persons are present? No, Mr.
Lordship, represent.
Who are there?
The accused persons.
They are there.
Yeah.
আপনাদের কোন উকিল বাবু আছে? তাহলে সরকারি উকিল বাবু দিয়ে দেওয়া হবে তো? All right. অনিরুদ্ধ বিশ্বাস. Yes, next matter.
And for the petitioner, your lordship, same FIR, different order sheet, so to cancellation of
Oh, the
bail
same
application.
order, so it's all over. 21. Yes. What steps have you taken, Mr. A?
My lord, all steps have been taken pursuant to the, my lord, the honorable division bench order, my lord. My lord, may I hand over the copy which your lordship has directed the last occasion? The SP shall file a report
Yes.
in this taker. May I hand over?
What are the number of bail bonds which are
My lord,
forced?
that I have included. I have included everything, my lord, all in detail. I have, because what happened lastly, the SP has not been properly advised. This is the reason, my lord, that such cryptic, my lord, the report was submitted before your lordship. My lord, kindly see, first he has constituted the SIT. My lord, at page, my lord, at page 11, my lord, in my report, first he has constituted the SIT, my lord. And then, my lord, there was a report has been called for from the, my lord, the DSP, my lord. He submitted a report in huge form. In light of that, my lord, the investigation should be progressed. Then, my lord, then accordingly, the prayer was made at page 13, my lord, to provide the bail bond, my lord. Lordship, kindly see the page 13. For seizing the bail bond. Now, my lord, kindly come to the next page.
What is more important is, who are these accused who are now on bail on the strength of the forged bond?
No, that I am saying.
So the accused should be notified, and at the first, what should be done, subject to what you feel, is they have to furnish fresh bonds.
Exactly.
Otherwise, they should be taken into custody.
Exactly, my lord. Because on the satisfaction of the
And they should be, the first thing, your Kaushik Bonik, appearing, the lawyer is there.
My lord, I am appearing for the respondent number 8. I am led by Mr. Saurabh Chatterjee, my lord.
Kaushik Bonik.
My lord, Kaushik Bonik, my lord. My lord, by handwriting
that man
sample
has to be interrogated.
My lord, that man, my lord, see in page 14 on the basis of the prayer.
Noise cancellation on Kalman.
Huh?
Here,
Mr. Babe,
my lord, the landed CGM was directed to hand over the bail bond to the clerk in charge, my lord. Then, my lord, pursuant to that, my lord,
Now-
only 64, my lord,
huh,
the bail bonds were supplied.
huh,
Page 19, my lord.
huh,
64.
huh,
Now, my lord, page 64, the 64 bail bonds which
Huh.
has been seized,
huh,
which has been correlated.
huh.
Then, my lord, what we have seen
No, the,
that in the
m-
maximum bail bond,
huh.
the respondent had signed and
Correct,
identified.
where he has signed, keep them apart.
My lord.
Where his signature, either he admits his signature or the verification, it comes out that it is his signature, it is away, kept apart. If the accused runs away, they initiate proceedings against him.
Well,
Correct?
my lord. And the
So
pursuant,
far as the other bail bonds,
yes,
in respect of which his signature does not match,
exactly, my lord.
that is the area for
area
investigation. in
that
this.
my lord, I am indicating. My lord, what happened?
Because our concern is not to protect his suretyship. Our concern is more
Who
to
has
clear the deck in administration of criminal justice.
exactly, my lord.
Today you have not less than 16 bail bonds
Yes.
where the accused have been released on the strength of forged
Not 16, my lord. 64.
64.
First, initially, which the landed SCGM has supplied us.
All of them are forged.
Maximum, the signed by the respondent, my lord. Maximum bail bond identified.
Now,
Then, my lord, in
no
terms
bail
of the
bond, apart from bail bond,
my lord,
he has furnished surety also.
surety in the name of the my lord petitioner.
That is what we are saying. So petitioner stood as surety.
Yes, it is signed.
He also signed on the bail bond.
Yes,
Correct. Apart from the petitioner,
yes.
was there any other person who stood as
No,
surety?
no.
No
It-
one
no,
stood as surety.
no. In 64. Now,
Now,
what happened? my lord?
Kaushik Bonik is the lawyer
Mostly,
in most of these
most of
cases.
the 30 out of the 64, my lord, we have
So
examined.
you require in closed interrogation of Kaushik Bonik.
I have
One.
indicated.
One. Secondly, what about these accused person? Are they appearing in court or they have absconded?
My lord, that I am indicating. My lord, if your
Because if
lordship-
they have absconded, then the
The-
damage already done.
Done. My lord, kindly see
If
the,
they are appearing in court, ask them to furnish fresh bonds.
my lord, kindly see the district judges, London district judges report, my lord.
Yes.
Once, my lord.
Where is it, page?
My lord, it is, my lord, I have not annexed already. It is in the my lord, sealed cover. It has been kept in a sealed cover. My lord.
Bilkul.
First, initially, my lord, London CGM has caused an inquiry. Then the London district judge even was directed. Which we have obtained, my lord, after your lordship's order.
This is the CJM's report.
CGM and
No,
district. Lordship, if you see the first page, my lord, Lordship got it. I didn't see. Sorry.
This is the question document.
Question document as well as the London district judge's report, my lord. Both were under the kept in a sealed cover.
Please bring it up.
I'll find it.
This one.
My lord, would
This is, my lord,
This is not
the
the
question document, my lord. This is not
Yes,
the.
this we have got it.
Yes, your lordship, got it. Second page, lordship, yes, second page, after the forwarding letter, my lord. My lord, the second paragraph, my lord. If your lordship see, I have obtained report from the Chief Judicial Magistrate Alipurduar Annexer in details, and the report reveals from the year 2014 till 2022, the bail bonds in number 2954. My lord, wherein On the basis of our prayer, only 64 bail bonds were supplied and seized, my lord. Now he has given the details, my lord. Now in the detail, my lord, what he has said, next after the chart, my lord, those bail bonds were paid before the chief judicial magistrate and other judicial magistrate of the judgeship for acceptance and duly accepted by the concerned PO. It has also been reported by the chief judicial magistrate Alipurduar C. Sukhendranath Bonik, advocate, what enlisted advocate surety in 2002. File number such and such. Initial capacity, my lord, is 50,000. Kindly mark it. Now, my lord, I am asking myself, if our initial capacity was 50,000, it has not been enhanced from 2002. Then how 2954 bail bond can be accepted, my lord? It is my anxiety, my lord. Then, my lord, kindly
So the
come.
report to the presiding officer
Yes.
by the bench clerk
Yes.
was without application of mine.
And even
Mechanically, the bench clerk has been endorsing
exactly.
a person's capacity
They
to
should
stand as
mention the
surety
capacity.
without verifying from the surety register.
They must write the
First,
capacity.
you will be knowing, Mr. Chaudhuri,
Mela.
that as soon as, let us say if it is 50,000,
Yes.
there is under the civil criminal rules and
Rules and
orders,
order.
you have a surety register.
14B.
Yes. And in the surety register, as soon as the entry is made,
Yes.
the case number and the quantum is addressed. So to that extent, his suretyship is reduced.
Yes.
So, and then when he does not have the capacity, he won't
Exhaust. Exactly, my lord.
So that you have to get the surety register.
Exactly, my lord.
How the surety register was entered.
Yes, my lord. Now, my lord, the one most, my lord, my anxiety in my report. my
Who
lord,
are these people?
My lord, my report.
Have you got the list of the bench clerk who was managing the surety?
My lord, kindly see what I am indicating. Kindly come page 19C. 19C, my lord. Kindly see 19C. How the bench clerk accepting the surety without mentioning the capacity and the used and exhausted. My lord, this is the bail bond to be, my lord, this is one of the sample I have brought from Siliguri. Capacity should be written, then liability should be written, the balance should be written, then acceptance should be there.
You ask your officers to inquire into the surety registers.
We are doing that.
And identify, you have to establish identity and responsibility.
My lord, there are other, may I submit, my lord, because, my lord, it is not been reflected in my report. Because 2954 minus 64, I have asked to seize all these rest. Few I have gone through. Other advocates are also involved. I'm very much
No difficulty.
in front of the.
We have made it very clear, Mr. Chaudhuri, and at least as the additional advocate general of the circuit bench, I don't think you will stand up for the black sheep of the
I have already.
The black sheep of the profession has to be identified.
Exactly, my lord. This is my effort.
And our clear indication on the last day is the black gown is not an immunity for criminal act.
I have indicated in my report.
It should be the stop to the criminal act.
For the truth.
Yes, you should act as a bar so that the clear stream of justice is not polluted by undesirable elements. Otherwise, you cannot sustain the institution.
That only
you indicate, you give our periodic.
I am monitoring.
And we are making it very clear that the district judge concerned and all associated with the district judgeship will give cooperation to the investigating agency to unravel, hand over all relevant documents with regard to this unholy practice of furnishing forged fabricated bail bonds or through persons who do not have the capacity or their capacity has been exhausted.
I think your lordship in other occasion had formulated SOP. They are requires also SOP to be formulated.
That you give us a proposal.
My lord, I will.
Your law
the moment I have seen it, my lord, I have.
Today, let us put it, this may not be unique to the district judgeship of Kuch Bihar. This may be endemic in various district judgeships.
I have obtained the from
we are not enlarging the scope because we are not hearing a public interest litigation.
Exactly, lordship.
But what we intend to do, at least clean the stables in the district judgeship of
My lord, I will.
Eh,
This minute,
Alipurduar.
This
Sorry.
ministers, my lord, I will.
This is absolute.
Absolutely, my
You
lord.
see, there are two areas which are of most concern. A, the suretyship, as a person before us is standing, he is not even aware that his name is being utilized.
But once surprisingly, 2002, he has relinquished his practice or suspended whatever. Not even a letter addressing to that. I have stopped practice, or I do not wish to practice further. Not even in the record. In 2023, he has come up said that no, I do not practice. So this, my lord, this is the reason, my lord. One
Sir,
of the
we
reason.
are not giving a clean sheet to the appellant.
Exactly.
If the appellant is hand in glove with the miscreants, you are entitled to pursue and investigate the appellant also.
Yes, I will.
But our concern is elsewhere. Our concern is the appellant, in all probability, maybe a name lender. Maybe a name lender. But who are the prime players in this organized racket?
So many. My lord,
You need to identify these prime players and give a
They
report.
are all the difficulties of the members of the bar, your lordship.
So what can be done if they are members of the bar?
My-
Put them in the right place where they deserve to be.
But
Add them as accused persons and let them proceed to take their legal
I
recourse.
have initiated reformative measures.
There is no scope for reformation.
Onwards, from onwards.
There is no scope for reformation. There is only one scope, that is investigation, unraveling of liability and prosecution.
I will do that. I have indicated
If
my
that
report.
is necessary, as soon as you file the charge sheet against these lawyers, we will initiate proceedings against them for disbarment.
My investigation will reach to the logical conclusion. I am telling you. This is my undertaking before your lordship.
We keep this on record.
Yes, lordship.
Mr. Cho.
Lordship, I want to submit one thing, my lordship. From beginning of this matter has been filed before this court. No reports which is filed before this court. No reports my lordship. কোনো রিপোর্টই আমরা পাইনি my
তো
lord.
আপনাকে এখন আমি রিপোর্ট দেব না। আমি
My
রিপোর্ট
lord,
যখন দরকার হবে দেব।
My lordship.
আপনার বিরুদ্ধে যদি কোনো পদক্ষেপ হয়, I will involve you in the reports. All right.
my lord,
Yes,
my
Mr.
lord, my lord, with
Gordon?
regard to respondent number 8, my lord,
Yes.
on a previous occasion, when the matter was pending before the single bench, a direction had been issued upon the learned additional chief judicial magistrate Alipurduar to take signatures of the respondent number 8 as if required. Notices were issued, my lord. I have cooperated with that.
We
Report
will
to that
record
effect
your
has been
submission
filed.
on that score. We will record your submission. on
That
So, my lord, I have
the
been
bureau,
cooperating, my lord.
Report
My
from the
lord.
bureau is not mismatching.
My lord,
Mismatch
the
between
signatures.
appellant and the
Yes.
bond.
Someone has
The
in the name of.
The question is advocate, the respondent number 8. His
My signatures are
is
also there.
matching.
No. His signature is not matching.
His signature is, let us see.
The sample signature is already there with the learned
Bureau's
ACJ.
report, my lord.
His signature is not matching where?
My lord, in the section of my lord, kindly see in the bureau's report, questionnaire document, opinion, my lord, part. Opinion part, report. Question document, examination bureau, opinion part, page 3. Lordship got it. The opinion, the person who lordship got it. I'm sorry. The person who executed the specimen signatures marks S1 to S18 did not execute the disputed signature marked Q. This is the first opinion. And then, my lord, the concluding opinion, my lord, comparison between the signatures marked A1 and A18 and Q is not possible.
Why? Why not possible?
Then the question document examination bureau does not undertake the examination of fingerprint related matter, hence correspondence may kindly be made. That below on
Now, S1, A1 to A18 are whose signature?
Q1 is Milord the Sukhendranath Bonik.
So, Kaushik Bonik, there is no conclusive opinion.
No conclusive opinion. No.
No conclusive
No
opinion. Now,
fingerprint. Now fingerprint.
whose fingerprint?
Now this is the reason the question document examination bureau does not undertake the examination of fingerprint related matter. Hence the correspondence may kindly be made with the director of fingerprint bureau CID. The moment we have seen this report, Milord, 3 days back, now we are contemplating to do that.
Did you take the fingerprint?
Yes, Milord, the moment, because it was not available to us. It was under the sealed cover, Milord. And your lordship's direction, Milord, we have obtained it just on 24th.
Well, kindly sees whether these signatures are the signatures that were taken by the learned ACJ, because that is the time when I was called to the court. I cooperated. There's a reflection in the learned ACJM's note, this report to this Honorable High Court, that I've cooperated and I've given sample signatures.
Question of cooperation does not exonerate you from anything.
Does not.
It's true.
If the report incriminates me, then
Yes, absolutely.
So how the examiner is saying your report?
Yeah, that bureau report, that.
We are trying to understand the bureau
Yes,
report,
yes.
which says that specimen signatures do not contain similar text or combination of letters
Yes,
as occurring in signature marked Q.
yes.
How that is possible? If the if the person is the same, then similar marks and combination of letter and character is not there.
They are saying that.
How are they saying that? This is exactly, Mr. Chaudhary, your investigating agency's requirement that you ask for.
The moment I have, this is the reason, the moment I have seen 3 days back, Milord, this report.
So
Milord,
after that,
yes,
has there been a more clarification obtained from this examiner
we-
that
we-
how
we-
are you saying this?
we are contemplating. We have seen.
You are not contemplating. Your report does not
We
say
have
any
seen
contemplation.
3 days back. Because this
The
report was
model
not
and
made available
structure
to us.
formation of signature
Milord-
so and so does not agree with that of A1 to A18. Let us see what is A1 to A18.
A1 is Kaushik Bonik. They have prescribed that differences in individual characteristics.
Specimen signature. So the specimen signature. No specimen signature. Question signature গুলো তো নেই। A1 to A18 are not before us. Only Q. This is Q.
A1, Milord, it has been provided to us, Milord. This is the bureau's report.
No, in bureau's report,
Yes.
what the annexures only show us the
This is the signature.
this is specimen signature.
This is specimen signature.
And where is the question signature? Q? Where is Q?
Q
Which
is
Q?
Q is Milord. It has not been provided.
This is not Q.
Q has not been provided, Milord. Q has not provided.
Because what we are really not understanding is if जामीन नामा नहीं ये तो it's not a signature.
This is not Q, Milord.
This is the Bonik. This is the other man's signature. Bonik signature.
S is Sukhendra Bonik, appellant.
Kaushik.
And A
Bonik
is
in Kaushik Bonik there is no signature, no?
no A. So
A R This Shubhendranath Bonik, oh, that is the queue. Okay.
My lord, may be pleased to take up can 2 once, my lord. Can 2 of 2024. Stay
So the
application filed
thing
by the
is,
applicant.
Kaushik may not have forged,
My lord.
but
But he has identified, he knows
so
who has
he
identified.
knows exactly.
He knows,
We are following.
because I am the lawyer, I have identified,
All
I know who is the person.
My lord,
This is here I am, my lord, banking on.
You have to, I mean, you have to continuously everyone trying to cover up. Try cover. Try cover.
my lord, two things, my lord. Well, may I
Yes.
humbly submit 2 things, my lord. My lord, firstly, my lord, even my signature, I was made to sign in the name of the appellant, my lord. As far as the
Okay.
learned additional chief
No,
judicial
no, no,
magistrate is
no.
concerned, that is at page 83 of
You
the can
were,
2, my lord.
you were,
My signature was taken.
you were made to sign in your own name.
My
They
lord,
want-
even in the appellant's name, my lord, kindly takes up can 2 once, my lord. They have annexed it at page 83, along with the report of the learned ACJM.
We are seeing the specimen signatures.
Given to
Yes.
whom, my lord? Kindly see.
You have given specimen signatures only as Kaushik Bonik, not
My lord,
as
kindly takes up the report of the learned ACJM as annexed to can 2. I have also given my signature in the name
very
of the
good.
appellant.
There is no
That can be
verification.
sent.
There is no verification on that premise, all right?
So, my lord, that can be sent for verification. My lord, I cooperated on my side. Secondly, my lord, the name.
Your cooperation is tell us in what circumstances signature of Shukendu Bonik finds place in the bail bond.
But that's all. That's
My lord,
Tell us
I-
your cooperation
My
is over.
yes.
My lord, I am not the person who wanted to sign those
All
bail
right.
bonds. My lord,
All
my
right.
name has been
Report,
dragged in. My lord, there are cases
Superintendent of
pending between
Police
the appellant and me.
Alipurduar, peruse report of Superintendent of Police Alipurduar. The report shows the report notes as follows. A EOP. The report shows notes as follows, full stop. The from the aforesaid notings, it appears that the investigating team has has seized 64 bail bonds and 64 out of 2950 bail bonds.
64 initially, now it has learned, now we will cease below.
64 out of 2954 bail bonds.
Well, from the report of the London District Judge 2954 has come.
This district judgeship is a prayer has been made to the concerned to the authority concerned to hand over the remaining bail bonds.
Yes.
District judge shall take necessary steps to do the needful.
And the bail bond register also, my lord.
The other relevant documents maintained with the district judgeship, it shall be open to the investigating agency to make inspection, including seizure of authenticated copies of records maintained with the district judgeship for investigation purposes. For investigation purposes. It is also noted in the report that most of the bail bonds had been filed by one Sri Kaushik Bonik, had been filed on behalf of accused who were represented by one Sri Kaushik Bonik, learned advocate.
Out of that 64.
কি বললাম, it is also most of the bail bonds have been seized bail bonds.
Yes. Grateful.
Bracket is 64 in number.
Grateful.
Also. This raises suspicious circumstances with regard to the role of the said advocate in furnishing the fake bail bonds. Mr. Ghotok contends Mr. Bonik has cooperated with investigation and handed over his specimen signatures before magistrate. Report, handwriting experts report would show that his signature did not tally with the forged signature of the appellant, namely Shukendra Nath Bonik.
Also, my lord, previous disputes and cases pending before the appellant.
It is also, he also submits that there are disputes between him and the said
criminal cases.
Shukendra Nath Bonik, and cases have been pending by and between them. Be that as it may, it is undeniable that the bail bonds were forged. Bail bonds purportedly furnished by Shukendra Nath Bonik have been found to be forged. Manner and circumstance, respondent number 8, Mr. Kaushik Bonik, respondent number 8 was the lawyer, was the advocate representing the accused in most of such cases.
While identifying in the bail bond.
He had identified the accused in the said proceedings also. Manner and circumstances in which forged bonds were furnished on behalf of the accused is within his personal knowledge, would be within his knowledge and would require effective interrogation for disclosure of relevant facts, for unraveling relevant facts. Full stop. It is also important to note that the role of, it is apposite to record the role of an advocate in judicial proceedings is to act as a sentinel quid vive in ensuring the purity of the proceeding itself. The facts unraveled prima facie show suspicious role of Mr. Bonik in identifying accused.
Kaushik Bonik.
Kaushik Bonik in identifying accused who were released on bail, who were released on strength of forged bail bonds. This forged bail bonds. Mr. Choudhury contends there are other members of the profession who have also identified accused who have been released on strength of forged, who have been released on strength of similar bail bonds. We direct the membership of the legal profession. Membership of a legal profession is not an immunity against crime. Investigating agency shall be at liberty to investigate into the roles of members of the legal profession who indulged in unlawful and criminal activities and enabled accused to be released on strength of forged bail bonds. In the event the said, in this regard, in agency would also investigate the roles of the staff of the judgeship who were responsible for certifying the bonds for recording satisfaction, requisite satisfaction by the presiding officers. All document, it shall be open to the investigating agency to interrogate the officers, to interrogate the members of the legal profession as well as the staff responsible for maintenance of record, maintenance and certification of bail bonds to unravel the truth, to unravel the crime and its ramification, which seriously erodes the credibility of the criminal justice system. Judicial officers concerned shall also shall take steps in the event the accused who have been released on strength of wherever accused who have been released on strength of forced bail orders have absconded, the judicial authorities, the investigating agency shall take steps for their immediate apprehension.
But the list be provided in that league.
Sir, we have already said necessary documents will be given.
That not so.
Full stop. In the event the said accused are appearing in court, they may be interrogated with regard to the circumstances in which forged bonds were furnished on their behalf and necessary steps be taken in accordance with law. Full stop. Further report, the Superintendent of Police shall conduct the investigation under his direct control and supervision and District judgeship and the staff concerned shall render all assistance to the investigation and hand over relevant documents whenever necessary in accordance with law.
Yes.
Further report be filed on it shall be open to the investigating agency to arrest, to subject suspects to custodial interrogation to unravel truth and ensure smooth progress in the investigation. Further report be filed on the adjourned date. We are taking very serious note of this.
We are also.
We're taking very serious note.
I will not leave any
This
gap,
is
any flaws.
not done, and we would request the Superintendent of Police also to take appropriate attention to this.
If you see the
If we turn a blind eye, and we are never saying that Shukendu Kumar Bhaumik is a innocent person, or are we saying that he is hand in glove with others? But it seems to be improbable on the first blush because Kaushik Bonik and Shukendu appear to have inimical relations.
Yes.
If they have inimical relation, then on this plane, they will cooperate and conspire. You have to see it and that.
That part also we are taking.
Because Mr. Patuk said that they are inimically disposed. We have noted it. If inimically disposed, then how can Shukendu and Kaushik conspire together to fraud, to create these bonds? Or in probability, maybe he utilized the name of Shukendu, knowing that Shukendu. So take necessary steps, whatever available in law. However, don't restrict it only to one person.
No.
Keep your mind and investigation open as an open-ended one. All right.
Yes, Lordship.
That is our request to you.
Malad,
This is not a witch hunt. This is neither.
I'm grateful, Malad.
This is neither an exercise in pursuing an individual.
Exactly.
This is an effort to clean the stables,
Society.
to clean the stables and identify the black sheep of the family, of the profession.
We'll do that.
That needs to be identified.
Well, lastly,
The minute you identify Mr. Chaudhary, you will find the quality of the profession improves.
improved. Exactly, Lord.
Because the bad elements are offloaded.
It's eliminated.
Better lawyers come to the fore. If
Well, two things,
Well,
Your Lordship, just a second. Well, may I, Miller? The SIT team be Miller discharged. Personal appearance was called for Miller by Your Lordship's directions.
who is presiding the SIT?
The SIT presiding is the DSP.
So the DSP will be present. We are not requiring the superintendent to be
No,
present.
no, not superintendent. SIT, including the three men.
We want the deputy superintendent of police to be present. The head of the SIT. will be
Next, when the
present
report would be.
whenever the
Report would be. All right, Miller, I will ensure. Number two, Miller. Number two, the police, there was a direction to provide the police protection to the.
Yes,
Miller.
you will go on provide.
That Miller,
Lord.
You will provide it.
My lord, as far as the report is concerned, my lord, it is in that report that it is stated that out of the 60 plus matters, bail bonds, most were cases in which I was involved. My lord, may I at least have access to that, because it is on that basis your lordships are passing the order.
When you are being
for-
interrogated, you will have relevant access. We will
My
give
lord,
you access.
because my lord, I should be able to answer
That is why you will be
whether
interrogated.
the report is correct or not.
Mr.
My lord,
We are
my lord.
there is a monitoring of the investigation.
My lord,
Please be sure they will, when they interrogate you, they will give you all relevant data.
my lord, what I am afraid of, my lord, is if this disintegrates into a witch hunt against me, my lord.
We have made it
My
clear.
signature
We
is
have made
not-
it clear. The
Well,
investigation will be under the supervision of the SP.
Don't be apprehended.
No, the apprehension is always there when we
Well,
have just in the morning spent more than an hour
Yes.
on an
Well,
investigation where the police is unaware which two persons died under suspicious circumstances, whether the death is suicidal or homicide. Okay. So here an apprehension of indifferent investigation always is there.
My
It is
lordship,
When
I'm grateful, my lord.
is there, my lord, all this I
Yes,
eradicate. my lord.
lordship, in earlier orders.
4 weeks, after 4 weeks.
My lordship, এর আগে যে
It is
রিটটা
a 6
হয়েছিল,
weeks,
রিটের পরে এখানে ম্যাটে
4 weeks.
হয়েছে, সেই রিটে
For
একটা
1 month. My lord, 2954 bail bonds.
But we want periodic
Periodically.
reports. 2954 is not the headache.
Periodically.
64 is good enough. Prosecute the 64 persons who are there.
1 month, 4 weeks.
মাই লর্ডশিপ, এর আগে যে রিটটা হয়েছিল সেই রিট ডিসপোজ করার পরে ম্যাটটা ফাইল হয়েছে, সেই রিটে ফার্স্ট অর্ডারটা বিবেক চৌধুরী জাস্টিস দিয়েছিলেন। সেটার মধ্যে একটা লাইন লেখা আছে যে রেসপন্ডেন্ট নাম্বার 8 আর অ্যাপিলেন্টের মাঝখানে সিভিল ডিসপিউট আছে। এটা একেবারে মিথ্যে মাই লর্ডশিপ। ওনার সাথে আমাদের কোনো সিভিল ডিসপিউট নেই। জবে থেকে এই অ্যালিগেশনটা আমরা জানতে পারলাম যে এরকম সিগনেচার ফোরজারি করছে, বাবা অভিযোগ দিল, তবে থেকে ও
ম্যাডাম, আপনার ডিসপিউট যদি না থাকে, there is a possibility যে দু ভাই মিলে ওনার সইটা ফোর্জ করে বন্ড ফাইল করে যাচ্ছেন এবং দুজনে both of you are sharing the spoils of the crime. ঠিক আছে?
মাই লর্ডশিপ,
So we keep everything open, madam. All right? There is a submission আপনার আপনার কাকার তরফ থেকে যে সম্পর্ক খারাপ সেটা নোট করা হয়েছে।
মাই লর্ডশিপ,
তাতে কিচ্ছু যায় আসছে না। আপনার বাবা যদি জেনে শুনে অন্য লোককে তার সই ফোর্জ করতে দেন, সেখানেও কিন্তু হি ইজ কালপেবল। সো উই কিপ দিস। নিশ্চয়ই কেউ কিচ্ছু করেনি স্যার। দ্যাট ইজ দি বিগেস্ট ড্রামা উইচ প্লেজ ইন কোর্ট। Everyone is innocent. And then we start and come to probably correct and sometimes unfortunately wrong conclusions. All right. So that is neither not a big surprise that you come up for your father and say that he didn't know. We accept that as of now.
I submit that civil disputes are there now.
All right, madam. We have made it very clear.
criminal cases have been filed.
There are criminal cases, he says, fine. If they are lodged after the case, fine. But they have got no impact on the investigation of this case. All right.
Grateful.
Superintendent police is present.
No, no, so
Ah.
the, just a second.
Who is there?
SIT, the three members are present.
They will be present.
So the DSP will be present the next time.
Who are the three members?
One is the inspector in charge of the Alipurduar police station, one is investigating officer, one is DSP who is heading this.
Now, all the three officers will be present. Members of the city is present. They shall appear on the agenda.
Adjourned date at the time of filing progress. Grateful, we will do that.
Or who is the leader? DSP is the
DSP.
leader. So they'll let DSP be present.
DSP present. DSP.
DSP shall be present.
Grateful, Malak. But I will ensure that I take
Yes,
care.
the next matter is Mr. Mojumdar. So we take it up at 2 p.m.
2 p.m.
You have got the report. You have got the report. Have you given it to Mr. Nisho? So what? You are relying on it official document. What open? You give it now so that we can address. I know. We know everything. We learn from both of you.
We learn
from both of you.
No.
So our knowledge of the internal administrative instruction is near zero.
No.
So it is your assistant that helps.
Malak, it is not.
All right.
It do not reflect.
So Mr. Chaudhary, this matter, this will go on 2 p.m.
Yes.
We will take up this matter.
I have a 23.
And
25.
then we will take up 23.
Yes, Milo, that is I am.
After 23, we will go to the criminal matter.
All
at
right.
2 p.m. All right.
All right.
Other matters we will not take.
Lost. Grateful, Milo.
Grateful.
Finally.
Where is he? Yes. Thank you.
Chapter 9, section 121 of the law. 192. And then we have to take number 6, the relevant. So that was, we understand the entire thing with the correct perspective. I was from 121 to 192, so all of them have to be read together.
Exactly.
121 will say that the GFC and the EFC, they require
Confirmation.
but not the SS.
128.
120 not the 122 and 123 also important. 122 not pertains to GFC, 123 pertains to 126 the final sentence of GFC may be confirmed. And for PFC is 120. So what we carry from here is that SLC per se does not require any confirmation.
Again, 128 clarifies that.
Section 130. It is only not in my humble submission, it is only in respect of GFC and PFC. Why I say so?
Okay.
Because from 185.
Mr. Mishra, point taken. We'll answer that. To us, 132 is DIG is empowered.
Lordship, DIG, not DIG, my lord, the officer who can exercise powers of section 132 will derive his powers from section 168 and 185, being the prescribed officer. So, my lord, my lord, I was hoping that Mr. Dhar was ably assisting Mr. Mishra, who himself was a DIG of this frontier, and who knows that sector is commanded by DIG would come.
All right, that is when he was DIG. Sit down. You don't have a chair. Chair. Sit down.
My lord, first document that we have filed.
So let us show us 185. How you are deriving the power.
Lordship.
Just one. The prescribed officer shall be the officer commanding a frontier sector or training institute
Lordship.
in respect of which proceedings confirmed by him or by a person under his command.
Lordship. So if I be a person who either commands a frontier sector or a training institute, I am qualified to become a prescribed officer, and I am qualified to invoke my powers under section 132, that is the annulment of a proceeding.
But you must relate to that frontier or sector.
No, my lord, that frontier, that sector, I cannot take over because there is territorial jurisdiction.
That is what
I can only take up cases of my frontier and my sector, which
that
happened
is
in
what
this
we
case
are.
also.
You are, according to you, you are the commanding of you are the officer commanding a sector.
No, my lord, officer commanding a sector necessarily a DIG, because what DIG is given, my lord, comes to the second page of the bunch of documents we have filed. Has your lordship found it?
Yes.
Authorization of sector headquarters. Old sectors: Gorakhpur, Lakhimpur, Kheri, Pilbhit, Muzaffarpur, Purnia, Rani Danga. This is where we are now. Bongaigaon, Bezpara, Alwar, and Bilai. First one is DIG. Then chronologically the ranks are given. So the first person in the sector, number one person is the DIG. My lord, then after, just my lord, may kindly skip one page. My lord will find an office memorandum dated 23/5/2011. Now, this was restructuring of SSB. My lord, I would not bother your lordships with the details. An annexure list has been given, my lord. Sector headquarters boldly written on top. Just 2 pages. DIG is the person who will be the top man in the sector headquarters. And there is another document, my lord, which will be more clearly show your lordship.
So according to you, the sector headquarter is always
Commanded
commanded
DIG.
by a DI. Well,
So-
anything?
Now, my lord, if a DIG was commanding a sector headquarter, so he was a person competent to invoke the powers under section 132 and annul the proceedings.
Hmm.
Now, my lord, when on 14 to 2020, the proceedings were annulled by the DIG, whatever reasons he thought fit to annul it, the petitioner never thought fit to challenge it. But there was one line included in that order for fresh proceeding. And he could have very well challenged it and took up this plea that you are not a prescribed officer under 132. How could you do this? A writ could have filed at that point of time challenging the entire gamut of the thing. He remained silent. He remained silent till his appeal against the subsequent charge was dismissed. Now, another question was
Mr. Mojumdar, there we have short clarification from you. Divorce the powers of a sector headquarter or person commanding a sector headquarter. If a order in this nature was passed, annulling the proceeding and directing fresh inquiry, will not that amount to initiation of fresh proceedings without color of law? The reason why we made that effort to ask you that if he did not challenge it, when he is challenging the ultimate result of the proceeding, he is always entitled to challenge the initiation being without jurisdiction. That there was already a proceeding, there was a punishment prescribed, I have suffered 40 days in forced custody. Now you have annulled that earlier proceeding and directed fresh proceeding on same facts, albeit on different charges. That power of annulment and direction of fresh proceeding, according to Mr. Mishra, is without authority of law. And the commandant's exercise is on the strength of that order after obtaining opinion from the judge advocate, deputy judge advocate. So if that officer who directed annulment and direction for further proceeding lacks jurisdiction to do so, Mr. Mishra would argue that
what I could gather from his argument.
entire
He was banking.
that is why he is arguing the point of dictation. He says, who is this man DIG? Who is this man deputy judge advocate? They are purporting to be officers under 132. They are not. And therefore, they are actually dictating their subordinate commandant to act in a particular manner which they do not have authority to do so. You have relied on the annulment order.
That's it.
And that is why we wanted that was the learned single judge right in saying that lack of challenge to the annulment order cannot be countenanced when the new proceeding has ended in a graver sentence?
Yes, my lord, because in my humble way, I would submit that so long Mr. Mishra could
Mr.
demonstrate
Mojumdar,
that.
we are not with you.
No,
there.
my lord.
We are not with you.
No, my lord, let me.
According to us, the annulment order merges into the final order of punishment.
My lord, I must come in.
And when the final order of punishment is challenged, the annulment order naturally
My lord,
comes into question.
My lord, in the final order of challenge, your lordship has already indicated the writ court will not see the insufficiency of evidence,
No,
only
we are not.
procedural defect. Now, apart from double jeopardy and lack of jurisdiction in annulment order, there is no challenge from the petitioner.
So lack of jurisdiction in annulment order, according to the learned honorable single judge, was not challenged.
No, my
What
lord,
is the finding for paragraph 29?
no, my lord, even
Two
if the,
findings. One, annulment order has not been challenged. All right, we have followed your submission that there is power in the DIG
he
as
could
a
have annulled.
sector. क्या करेगा वो आगे करेगा तो करेगा चलो टेक डाउन appeal is directed against judgment and order dated so and so passed by the honorable single judge whereby dismissing the prayer to set aside the order of the appellate authority order of the appellate authority dated 1/1/2021, upholding the decisions and findings of the security force, a summary force court, SFC for short, wherein the appellant was found guilty under section 44C and under section 43 and 44C of the SSB Act 2007 and awarded punishment of dismissal of service under section 51(1)(c) of the said Act. Factual matrix giving rise to the appeal are as follows. On 13/7/2018, appellant was performing sentry duty at RP Gate 1 between 6 hours to 9 hours. At 8:55 hours, he was seen using his mobile phone and duty SO ASI GD Patto Bhattacharjee seized the said phone as the appellant was using it during duty hours in contravention of orders and directions issued, in contravention of the extant orders and directions. At that stage, appellant cocked his rifle. At that stage, there was an altercation and the appellant cocked his rifle. Full stop. Appellant was placed on now, in view of the aforesaid accusation, appellant was placed on immediate suspension. Full stop. A court of inquiry was ordered by the commandant with a convening order dated 17/7/2018 to investigate into the circumstances under which the appellant had cocked his service rifle while performing sentry duty. Pursuant to the Court of Inquiry report, the commandant, video order dated 3/10/2018, directed record of evidence in accordance with Rule 51, in accordance with relevant rules. Relevant rules. Pursuant to the record, after perusing the recording of evidence, the commandant gave an opportunity of hearing to the appellant and referred the case remanded the case, remanded or referred the case for, referred the case for summary for SFC under Rule 135 of the SSB rules. Accordingly, the appellant was tried by SFC, was initially tried by SFC on the charge of under Section 22 of the SFC Act, which reads as follows, page 57, page 57, full stop. Page 57. SFC found the appellant guilty of the aforesaid charge under Section 22 of SSB Act and sentenced him to suffer imprisonment in forced custody for 40 days. Video order dated 11/2/2019. The order was duly promulgated and the appellant served the aforesaid sentence. After a year, Now, after a year now, on 14/2/2022, 20, the Deputy Inspector General on analysis of the evidences on record. Now, upon analysis of the evidences on record, annulled the SFC proceeding, holding the same as illegal and against the evidence, holding the same as against illegal and against evidence on record. কি বললাম? On analysis of the holding the same as illegal on the premise that the punishment awarded was not commensurate with the gravity of the offense and evidence on record. Huh? Thereupon, the commandant cancelled the punishment, cancelled the earlier punishment of imprisonment in forced custody for 40 days awarded to the appellant and directed that the same shall be treated as duty for all purposes. Oh no, এটার আগে ওই thereafter the commandant obtained, now in view of the aforesaid annulment, the commandant obtained legal opinion from the deputy from the judge advocate general, from the deputy judge advocate general, who from the deputy judge attorney general, and the latter the opinion at 116 is of the and the and the latter opine at 116 a battalion to take action as per direction of DIG and complete proceeding immediately. Pursuant thereto, by order dated 4/5/2020, the commandant cancelled the punishment for imprisonment in forced custody for 40 days awarded to the appellant and directed the said period shall be treated as duty for all purposes. by a convening order dated 15 by a convening order dated, this is the convening order, the charge sheet. Where is the fresh convening order? After the charge. By a convening order dated 6/6/2020, a SFC was convened to try the appellant on the following to try the appellant for charges under section 43, 44C and 43 of the SSB Act, which read as follows, set out, page 180. In the courts, SFC video order dated 23/6/2020 found the appellant guilty on the aforesaid charges and sentenced him to dismissal from service. The sentence was duly promulgated. Appellant challenged the sentence before the appellate authority, which confirmed the findings and the sentence of the secure SFC. This came to be assailed, next paragraph, before the Honorable Single Judge under Article 226 of the Constitution in the present proceeding by the impugned order. Honorable Judge dismissed the writ petition, resulting in the present appeal. Mr. Mishro assails the proceedings on the following grounds. Firstly, he contends, referring to Rule 155 of the SSB rules, referring to Section 87 of the SSB Act, read with Rule 155, he contends that the appellant could not have been tried by the SFC afresh on same facts. He also contends the DIG concerned did not have authority to direct a fresh SFC. He also contends that the powers of the DIG in respect of SFC proceedings are delineated in Section 130, read with Rule 162 of the Act, and he had no authority to annul the proceeding, annul the earlier proceeding as illegal. Stop. Finally, he contends the appellant had, finally he contends finally, he also contends that the DIG is not a prescribed officer under Rule 185 and he cannot and could not have exercised powers to annul the proceeding under one. Acha, finally, it a reply to the. In response, Deputy Solicitor General submit the DIG exercise powers under section 132 of SSB Act. DIG is a prescribed officer under Rule 185 and exercised jurisdiction under section 132 of the SSB Act to annul the proceeding, on the ground that the earlier SSB proceeding was against was against the evidence on record, and the sentence was not commensurate to the gravity of the offense. In this backdrop, convening of the fresh SFC on new and distinct charges would not violate the would not amount to trial on the same, would not violate section 87, would not amount to a trial of the same offense. Would stop violating section 87 of the Act. 87 of the Act. He further contends that the annulment order had not been challenged in the present proceeding. In response, Mr. Mishra argues the annulment, Mishra argues that DIG is not a prescribed officer and is not a prescribed officer under Rule 185 and would not have exercised powers under section 132 of SSB Act. In the absence of legal authority clothing the officer concerned to annul the proceeding, initiation of the proceeding, initiation of the fresh proceeding, the fresh proceeding, which was initiated on the basis of direction, on the basis of annulment by an unauthorized officer, was patently without jurisdiction. Was patently without jurisdiction. Full stop. Was patently without jurisdiction. An analysis of the aforesaid facts in the backdrop of the arguments advanced would show advanced give rise to the following issues: (A) whether the initiation of the fresh SFC on charges under section 44C and 43 of SSB Act would constitute trial of the charged officer for the same offense, violating section 87, read with rule 155. 87 of ওই একটা rule, হ্যাঁ, ওটা আমি আর বারে বারে বলছি না। Section 87, read with rule 155 of the relevant rules. 2. Whether the annulment order passed by the DIG concerned is without authority of law. If so, failure without authority of law, rendering the entire SFC proceeding and the punishment awarded as illegal. Section 87 of the Act reads as follows. Section 87 of the Act reads as follows. Section 87 of the Act reads as follows. Set out 87. Rule 155 reads as follows. A combined reading of the aforesaid provisions, a combined reading of the aforesaid provision, section 87 of the Act reads as follows. Set out 87, best. Rule 155. No. Rule 155. 155. Not 150. Sentences awarded in respect of all the offences which the accused account. Rule 155 reads as follows. Set up. Section 87, a combined reading now. Section 87 provides in the event, section 87 puts a bar for trial of a person for the offense, for the same offense, a same offense টা inverted comma দাও, by a force court in the event the said person has been subjected, the said person has been convicted or acquitted of, now section 87 provides, sets a bar for the person of the said offense by a force court or a criminal court, or a criminal court. The applicability of the said section, the said embargo applies when the person has been convicted, when a person subject to the act, when the person has been tried and convicted / acquitted of the self-same offense. In the initial SFC the appellant had been charged under section 22 of the under 22 of the act, under 22 of the act, under section 22 of the act, whereas in the subsequent SFC, the the delinquent had been charged under section 44C and 43 of the said act. Section 22 of the act Section 22C of the act reads as follows: any person subject to this act who commits the following of any of the offenses, namely ... uses subordinate language. Where follows section 44C of the act you were tried with 22C, right? Acha. Section 22 of the act reads as follows. Now, relevant penal portion of section 22 of the act reads as follows. Bole 22 uses reads as follows. Whereas section 44C and 44C of the act makes an attempt to commit suicide and makes attempt to commit suicide punishable in the event the delinquent does any act towards the commission of towards the commission of such offense. Section 43 of the act makes an act or omission on the part of the delinquent which is prejudicial to good order and discipline of the force punishable in law. Plain reading of the ingredients of the three offenses, of the aforesaid offenses, that is, offense under section 22 bracketed, for which the delinquent was tried in the first SFC, and the subsequent and the offenses 44C and 43, for which the delinquent was tried and punished under the subsequent in the impugned SFC, clearly show that that they are not the same. They are not the same. On the contrary, section 44C, which prescribes section 44C, which punishes the officer, which punishes the delinquent for an attempt to commit suicide, provided he does any act in pursuance of such attempt, is a much graver offense than the offense under section 22 of the act. Is a much graver offense than the offense under section 22 of the act. Under section 22 of the act. Rule 155 relates to a different rule Mr. Mishra has relied on rule 155, which relates to a different set of facts. Rule 155 leads, Rule 155 provides when multiple charge sheets are filed, Rule 153 and Rule 155 relate to different set of relate to a completely different fact situation. Rule 153 prescribes Rule 153 prescribes Rule 153 prescribes the Rule 155 prescribes if multiple charge sheets are filed, if charges are contained in multiple charge sheets, the security force code, the SFC shall try the accused on each charge sheet separately and give separate finding on each charge sheet. However, a composite sentence shall be however, in the event the delinquent is found guilty on the charges, a composite sentence shall be prescribed. The rules relate to the procedure. The rule relates to the procedure of conducting trial in SFCs, where in the course of trial, where is the power to amend the charges and file 140. No, not 142. In the course of the trial. No, sir. 142 is not procedure. It will be in around chapter 8. Right. Ah. And multiple charge sheets were filed? One? কি বললাম the conducting trial in course of in during in SFC where multiple charge sheets have been filed, where multiple charge sheets are filed and findings are recorded independently thereon. The in the instant case, now this is in the instant case, the SFC, the initial SFC was not convened in the instant case. There was no amendment of charge in the initial SFC, nor multiple charge sheets had been filed. Upon the promulgation of the finding and sentence in the initial finding and sentence in the initial SFC, the same was annulled due to inadequacy of sentence vis-a-vis gravity of the offense, and a fresh SFC was reconvened. Full stop. As discussed earlier, the convening of the fresh SFC was on clear and distinct charges, was on different charges which are distinct from which are different from the charge on which the earlier SFC had been convened. The first issue is convening of the subsequent SFC. In this background, convening of the subsequent SFC, in our considered view, does not violate the provisions of 87 of the Act, nor does it attract the rules 153 or 155 as argued by Mr. Mishra. This brings us to the subsequent issue. Full stop. Was the annulment order by the DIG concerned suffer from jurisdictional defect? Mr. Mojumdar would argue that the order had not been assailed. On the contrary, Mr. Mishra strenuously contends that the order was dehors the scheme of the Act, and the entire proceeding was initiated on the dictation of a superior officer who had no power either to annul the proceeding, who had no power to annul the earlier proceeding. Rule in the and effective in support of his submission, Mr. Mishra refers to the powers of DIG adumbrated in section 130, read with rule 162 of the relevant rules. Section 130 and 162 of the rules read as follows. A combined reading of the said rules would show that the aforesaid provisions relate to the power of কি বললেন যেন section 130 read with rules 161 162 161 162 A combined reading of the said provisions would show that the said, that the aforesaid, no, a combined reading would show that the aforesaid provisions relate to the review power of the Deputy Inspector General in the event he is satisfied, in inverted comma, injustice has been done to the accused, inverted comma closed. They do not relate to the power of the DIG concerned in the in case the said officer is of the view the convening of the finding and sentence of the security force SFC is against the weight of the evidence on record, or the sentence is inadequate qua the gravity of offense. Such power is traceable to section 132 of the Act, which reads as follows. Mr. Mishra would argue the DIG concerned is neither is not a prescribed officer empowered to annul the proceeding. His action is divorce the statutory provisions and would amount to dictation unauthorized in law. Mr. Mojumdar has rightly, Mr. Mojumdar places on record relevant notifications issued by the department authorizing various officers in the sector headquarters. The authorization কি বললাম Mr. Mojumdar argues that the annulment order had not been challenged by the appellate. In the event the annulment order was the foundational fact on which the subsequent SFC had, pursuant to which the subsequent SFC had been convened, the jurisdiction and authority of the officer concerned issuing the order amounts to a jurisdictional issue, and can be assailed and could have been and can be assailed by the delinquent while challenging the order of punishment itself. For this reason, we have delved into the source of power, delved into relevant authorization of the DIGs, relevant authorization of various of the officers concerned, of the various officers with regard to their hence we have কি বললাম যেন relevant authorization issued by the department with regard to the power and function of the officers in the sector headquarters. Notification placed before authorization, office memorandum dated vide number so and so, dated 17/3/2022, placed before us, encloses authorization of officers holding different posts in sector headquarters. The authorization shows the hierarchy of officers posted in sector headquarters. Now, as per the authorization, the hierarchy of officers posted in the sector headquarters show that the DIG is the head of a sector headquarter. In such view of the matter, there cannot be any cavil to the proposition that the DIG is a prescribed officer, DIG is the officer, is a prescribed officer commanding the sector headquarter, empowered to exercise powers, empowered to exercise authority under section 132 of the Act. In the factual matrix, the DIG, the concerned, had gone through the evidence on record, and arrived at a finding that the earlier security force proceeding was against the evidence on record, and the sentence imposed was not commensurate to the gravity of offense. Accordingly, he annulled the said proceeding and annulled the said proceeding. Pursuant thereto, commanding officer, upon obtaining legal opinion from Deputy Judge Attorney, recalled the earlier punishment of custody, of imprisonment in forced custody for 40 days, and directed the period would be treated as on service, and initiated a fresh proceeding on separate and distinct charges for which the appellant was found guilty. The procedure adopted, in our considered opinion, is in consonance with the statutory provisions and the rules rules. It is also apposite to note that the appellant had accepted the annulment order, including the effacement of his earlier punishment, and participated in the subsequent proceeding. In such view of the matter, it cannot be said that either the annulment order was patently, inherently bad in law, or that the appellant in such view of the matter, we hold that the annulment order was in accordance with law, and the appellant had acquiesced to it by accepting the setting aside of his earlier punishment and the initiation of fresh SFC on distinct and different charges. In light of the aforesaid submission, we are of the opinion the impugned judgment and order does not call for interference. Appeal is accordingly dismissed. There shall be no order as to costs. दोनों नहीं देते acquiescence क्यों है वही बोल दिया advantage दिया you have to say. Yes, Mr. Torshati.
Yes, I am not Torshati.
Acquiescence, ACQUIESCENC. শোনো ওইখানে না ওই SSB Act hereinafter the act, said act, said rules. তাহলে তোমার সব জায়গায় said act or বা the act, rules, the rules. তাহলে ব্যাস। ও তো বাবু হয়ে গেছে, ওকে ও একা বসে শুনলো। করছি চলো তাই ওটা কর, এটা একটু বড় আছে তো। Yes, Mr. Mukherjee.
My lord, I appear for the respondent number 7, my lord, to whom, my lord, the tea estates have been, my lord,
Hey,
vested.
you have a second charge on the tea estate. Let Mr.
But I've already invested.
Mukherjee say how much he will pay.
Yes.
Then you come up.
Very
If
well.
you match his amount, we will give you right.
Very well.
All right.
May I just intervene?
My lord.
If you,
Yeah, buddy,
with
yeah,
your
buddy.
lordship's permission, may I intervene in the matter?
Who are you?
I am the 50% shareholder
Oh.
of the appellant before your lordship.
Oh.
I have been litigating with the appellant in NCLT for the last 4
You
years.
go on litigating there.
Now, there's an application pending before NCLT for appointment of administrator over the company.
Whatever, sir.
Now
First
we want
let us-
to, it's our interest also because 50% owner. If required, we'll put in funds if
All
we
right, you talk to Mr. Mukherjee and put in jointly whatever you want. First,
We
what
shall.
is the dues?
My lord, already your pursuant to your lordship's order, my lord, we have communicated 6 crores 31 lakhs 50,000.
What is the
Components. Components, my lord. The wages 27 lakhs. That is after the, my lord, the closure was declared. Before that, the, my lord, 2 crore 14 lakhs 50,000.
2 crore 14 lakh prior.
Prior to from my lord, 19th August 2024.
And after closure, 27 lakhs.
Yes, my lord. And my lord, the PF dues, as I said yesterday, that is for the, my lord, from February 23 to July 2024. Thereafter, we don't have a record. Rupees 1 crore 40 lakhs.
1 crore 40 lakhs.
And the gratuity is, my lord, 1 crore 70 lakhs approx. Bonus due 23 and 24, both the years, rupees 80 lakhs. So, my lord, totaling is 6 crore 31 lakh 50.
Yes, Mr. Mukherjee.
Yes, my lord, may I, my lord? My lord, I'll come straight to, my lord, what your lordship wanted to hear from me as to how I propose to make payment of the dues. Now, my lord, only one caveat, my lord, I must indicate. My lord, in the first paragraph, there are, my lord, maybe, my lord, certain, my lord, incorrect facts, my lord, have been, my lord, there in your lordship's order, but I'll come to that later. My lord, kindly take your lordship's direction, which said, my lord, that they would furnish us, my lord, yesterday with, my lord, the dues, my lord, breakup. My lord, kindly take the letter of 28th of January, 2025. My lord, may I request, my lord, Mr. Ghosh, my lord, to give your lordship a copy of that.
Hand it over, sir.
Yes, yes.
Now, my lord, wages, my lord, for 4 fortnights, my lord, is 27 lakhs.
Right.
My lord, this is, my lord, what was provided. The lordship's aware, my lord, 21 lakhs 99,900. We already have, my lord, my lord,
So, my lord, there is a
demand draft.
query in the, my lord.
No, I'm coming to that, please.
Lord, all right, sir.
I'll certainly,
No.
corrigendum, how it comes, when it comes, I'll, my lord, explain all that. Now, my lord, this is, my lord, it would appear from a subsequent corresponding letter of theirs, which is given today. My lord, is, my lord, 27 lakhs is, my lord, till, my lord, the shutdown. Declaration, my lord, of lockout. My lord, they have then enhanced this, my lord, to, my lord, by, my lord, this today morning by a corrigendum. My lord, they have enhanced it, my lord, to, my
2
lord,
crore.
my lord, 2 crores
14
14 lakhs
50,000.
14 lakhs 50,000.
Hmm.
My lord, this is what they have, my lord, enhanced it to for, my lord, during the period of suspension of work. my lord, legally, my lord, unless, my lord, it is established that, my lord, the suspension of work was illegal and not justifiable, my lord, no amount can be claimed. So, my lord, as far as the wages are concerned, the difference between 21 and, my lord, 27, my lord, I'm willing to put in immediately. So, my lord, that is the first. Now comes, my lord, the provident fund dues. My lord, here, my lord, the calculation, my lord, is, my lord, 1 crore 40 lakhs. My lord, our calculation, my lord, comes to, my lord, 74.69 lakhs. My lord, which we are willing, my lord, to pay, my lord, in 2 installments, which we are willing to pay in 2 installments. And, my lord, subject to determination under section 7A, my lord, of the act, your lordships may expedite it.
What
because
7A
summons-
determination? There is no 7A determination. You are running an industry, you have more than 10 employees. What 7A determination? No,
No,
7A
the quantum.
determination.
The quantum, my lord.
Quantum, we will, if necessary, what we will do is, we will call upon the Provident Fund Commissioner to give us a
Yes,
report.
yes, kindly do
What
that.
is
I'm
the
happy,
due?
my lord. Yes.
What is the due?
Kindly,
But
my
as
lord.
of now, you
Yes.
admit 75 lakhs as due.
Correct, correct. I'll pay
All
that in
right.
2 installments.
75 lakhs has to be paid immediately. And the Provident Fund Commissioner will give a report. What is the further outstanding amount?
Very well. Very
All
well.
right. Now,
Yes.
what about gratuity?
Now, my lord, as far as gratuity is concerned, my lord, the claim is 1.70 crores.
1.70 crore, right?
Yes, that's the claim. My lord, our estimate is, my lord, 66.17 lakhs.
The gratuity commissioner give a report from gratuity
Controlling authority under section.
controller.
Yes.
Yes.
So why
Let him
didn't you
give a
get
report,
these
ma'am.
reports?
My lord, this is the reports from that only.
Where is the report? Where have you enclosed them? This is a one pager. Where have you enclosed from which you are coming to the finding 1.4 crore is due?
Because till date, my lord, as per the provisions of AL, my lord, the notification which they have provided in a form of AL, we have calculated that this amount is due.
In the form of
AL.
So why don't you raise these documents before us?
Malad, kindly appreciate, my lord, yesterday evening, my lord.
So what?
My lord, this is the figures as of now.
So if you can show us that
Yes.
they themselves have declared this is the amount.
Yes.
Formal আমরা কোনো ফাইল করিনি।
Though my lord, I'm sorry, my
formal
lord.
file.
This is the form AL, they do not submit.
Okay, that is a prosecution.
Yes.
That is prosecution. So if there is a due, what is the amount due and payable?
Yes.
As per the Provident Fund Authority.
Yes.
That is under your government's control.
But the Provident Fund,
Hey, sorry, the gratuity.
The gratuity that within our control.
So show us from the gratuity controllers finding
We
that
will
this
find the reports from the controllers.
So they are saying as of now it is 67 lakhs.
66.17.
But my lord,
From where are you saying that?
This is according to our records.
Your consultation with client.
That which they have not submitted by a form
From
A.
where? From what is your record?
Not submitted.
You have not submitted any of these reports, which prima facie makes out a case of mismanagement. None of the employees' statutory requirements are complied with by the management.
With leave of Mr. Mukherjee, Millard, till 22 March 2022, all Provident Fund dues are clear.
Very good. They are never saying that.
From March
They are saying
2022.
February 23 to June 24, amount is 1 crore 40 lakhs. If that is so, sir, you have to put in that amount.
Now, Millard, so far as the subsequent period, Millard, a 7A proceeding is already going on. They have given us notice. Now, Millard, it has fallen from your lordship. 75 lakhs we have to put in. Millard, that Mr. Mukherjee has already submitted on that.
Which one? That is
They are willing to put in 50% of 1.
That is the PF.
PF. And here also they are willing to put in 50%. Okay, 7A proceeding. What is the notice in 7A?
Millard, I'll just show you, lordship. Millard, we have the
my lord, can I indicate the suspension notice once, my lord?
Milord, in this notice, Milord, they are considering the period March 2022 till May 2023. And we have been called for to produce the records. Now, by way of a reply, which Milord would find at the next page, we said that the suspension of work in the garden is suspended. So we'll immediately get back to them once we are having the documents. So
That
we're ready
is
to.
no answer.
No, Milord, we are ready to cooperate to that extent, Milord.
That is no answer.
So far as the admitted dues of Provident Fund are concerned, Milord has observed, we are ready to put
So
in
you
that.
have not put in any dues from February 23 to July 24. So it's very easy as per the role of employees.
Yes.
What is the amount you were putting in, let us say, in the earlier years?
Yes.
Will be the amount for every
Milord,
month.
that we have, Milord, we have also, Milord, prepared a proposal which Milord has sought for, Milord.
But sir, this you are showing us, it is for the period 22 to 23.
What is the
Yes,
ending
yes.
of?
Now, the
That's right.
calculation which has been given by them is for the period 23 to 24.
Yes.
So
So,
the
Milord,
subsequent payments which are supposed to be given, what about that?
so,
What have
Milord,
you done?
up to, Milord, from March 2022 till today, Milord, we have indicated in our proposal, which have just handed a Milord, that so far as our office records are concerned, it will be 74.69 lakhs, which Mr. Mukherjee has already indicated to your lordship. That is in our proposal.
Proposal for the period, what is the period?
Milord,
23 to 24?
No, Milord, till date. Milord, till date from March 2022 till date. Prior to that, Milord, everything is clear.
So it means they have not paid? At least they have not paid from March 2022?
Correct. If they are willing to pay,
Yes, my lord.
it enables the
Workers.
This
is the Milord.
Your purpose is not to stand in the way of their
No,
running of
no,
the garden.
only purpose is that.
After all, one thing you must understand, Mr. Chaudhary,
My lord.
they are in possession and they were running the garden till
Lord.
you intervened or a
My lord,
third party,
or determined or
came into the play.
Yes.
Right?
Yes.
So in this situation, if this acts as a terrorem to ensure compliance or substantial compliance of the shortfall,
Yes.
which is primarily revolving around their statutory responsibilities towards the workmen.
Yes, my lord.
Then on an equitable plane, the status quo may prevail.
My lord, then may I indicate one thing, my lord? We are concerned with regards to the workers.
Correct.
So the workers, my lord, the suspension, my lord, from July 2024. Now, my
That
lord,
we will direct the Labour Commissioner to take into consideration and take appropriate steps, because the suspension of work prima facie, according to us, is illegal. All right.
Yes.
We cannot make a finding at this interim stage.
And they say they are not
So let
entitled.
it be decided upon exchange of affidavits.
Yes. Yes.
In the meantime,
my lord.
if they show bona fides
Yes.
and make payments,
Yes.
then we will permit the status
The
quo.
payments means 2 crores. That is the wages, 2 crores something, my lord. If they pay, my lord, then we will be very happy, my lord. Why the SOP has been brought into, my lord?
So according to you, the wages outstanding, you gave a wage of only 4 months.
No, my lord. The wages, my lord, can you see the corrigendum of the 28th January?
It is 2 crores.
It is 2 crores. B, my lord. Unpaid wages during the abundance from 19/8 to 17/1/2025, rupees 2 crores such and such, which is being calculated by considering 650 workers for 130-day working days at the rate of 250.
No, there 17/1/25 is when again the works commenced.
No, then 17/1/25 respondent number 7 in pursuant to the SOP, my lord, had taken into, my lord.
Okay, so there is a stoppage of work
from
or
July.
They stopped the running of the
payment even.
Paying wages from August 24. That
Milord,
is from August 24 until 17th.
Yes.
And after 17th, they have paid
They
some
paid that.
21 lakhs.
Respondent number 7.
And respondent number 7 has put in some 14 lakhs.
Yes. No, they did not pay anything. The appellant did not pay anything as of now.
Okay, so respondent number 7 has paid 14 lakhs.
Yes, that is what is
14
the
lakhs and odd.
Yes.
That is 14
Yes.
lakhs. and odd.
What they said, Milord.
Ah.
So, Milord, as
and Mr. Mukherjee's client said that they are willing, they had brought in some 21 lakhs.
Yes, that's ready with us.
Yeah.
But Milord, if they ready to pay 2 crores, Milord, 2 crores, the wages which has not been paid during the period of suspension, and Milord, the period from 27 lakhs, that is the fortnight period which is due. Together with that, if they pay, Milord, we'll be very happy. And with regards to the PF and the gratuity and bonus, if 50% they deposit, very well at this juncture, Milord. But Milord, they have to pay because
Mr. Mukherjee, with regard to that period of abandonment or stoppage of work without prejudice to your rights and contentions in any collateral proceeding, if you can pay 50% of that and the amounts that you propose with regard to the Provident Fund dues and gratuity dues, 66 lakhs and
My lord, will your lordship give me just 1 minute, my lord? Just
Yes.
1 minute.
let them at least pay 50%, no?
wages, Milord. Milord, my kindly see, Milord, this kindly have a look of the SOP by a gazette notification. May I hand over, Milord? Then it will be everything will be clear, Milord. Ektu. Milord, gazette notification 6/11/2024, Milord, kindly come to the SOP straightway, Milord. Milord, just first one. May I read, Milord? The standard operative procedure for grant of STS, short-term settlement of abandoned close registered tea gardens situated in the state of West Bengal on land which are under ownership of the government of West Bengal vested under the EA Act shall be applicable. A is not applicable to here, Milord. B, Milord, 1B. Tea gardens where leases have not expired, the leases subsists, but lessees have abandoned and or kept close the tea gardens for more than 3 months and not paid the dues
What
and
you are
entitled.
saying, please come to G.
G.
GI.
G.
You are permitting a bidder.
That is the second stage. Not today. That I will show you.
We are on this stage. If this person with running the tea garden can be compelled to pay 50% of the outstanding wages, you are allowing a bidder to bid and take over with 3 months salary.
No, my lord. No. Kindly see bilateral agreement which has been annexed. Kindly see the bilateral agreement then.
Then,
my lord, kindly read then D. Kindly read D, my lord, 1D. My lord, that is my lord, there are certain stages, my lord. May I explain, my lord, what happened, my lord? Now, my lord, by a bilateral agreement, if they step into and all the dues they are cleared, it is cleared and payment is made for the period of 1 year without any default on the first day of the month, then, my lord, we will assess it.
that is what we are saying, Mr. Chaudhary,
My lord.
that if the existing management pays substantial portion of the wages and their other dues and undertakes to continue to pay the wages in future, on that basis,
I have no problem.
So your purpose is
my purpose is my substantial lot, my lord. The dues which they did not pay from July. I am only concerned that because kindly, if they pay today means definitely a reasonable time. The lordship will give that 2 crores 14 or something, whatever the and 27 lakhs if they pay immediately.
2 crore is the outstanding dues for the abandoned period. Okay.
Abandoned month. Yes.
Abandoned month.
Yes.
As of now, under this SOP, how much do you get out of that? What is the arrears which you get? You don't get the arrears. You just get.
No, we'll get the arrear.
Yes, sir. How long? How far? If we can ensure that, or at least Mr. Mukherjee's client undertakes, here and now we pay 50%, and the remainder 50% we pay in 6 months.
Well, kindly see the wages. They are the livelihood, 230 rupees per day.
We know everything, but livelihood is one thing, but the use of appropriate measures to ensure a flow of livelihood is another thing.
Yes.
Today we have a defaulting
Management.
You have initiated your standard
SOP.
operator, which is disputed,
Yes.
that whether the action was under the SOP
They
or
have not
an-
challenged.
we are saying they are not challenging this.
No.
They are challenging an agreement or a purported arrangement between
arrangement by-
workmen and
Exactly.
respondent number 7.
Now,
We are not going into these niceties. The single
may I
judge,
put it in other way? If
Mr.
suppose,
Chaudhary,
if
let
suppose,
us understand, your headache will be over if Mr. Mukherjee does not say no. Says no to this, okay?
Yes, yes.
So then we will relegate him again to the first court. Yes,
Yes.
Mr. Mukherjee, are you willing to deposit 50%?
Yes, now,
of
my lord, now, my lord, as far as, my lord, so let's go, my lord, one by one, my lord. The first is, my lord, the wages up to the date of, my lord, declaration of lockout. My lord, that I've said, my lord, we pay immediately. My lord, whatever, 1 day, 2 days, 3 days, my
That
lord,
is
whatever
2
your
crore
lordship.
14 lakhs.
No. That is, my lord, the 27 lakhs which they have
27.
mentioned. Then the second is, my lord, the, my lord, 2 crores 40 lakhs odd, my lord, which they have claimed, my lord, for, my lord, the period, my lord, of closure till date. Now, my lord, I had initially submitted that, my lord, this is not payable till there is a determination on, my lord, the lockout. Your lordships observe
There
that,
is
my
no
lord,
lockout. There is
there
no
is, my lord.
lockout.
There is.
Suspension of work
Because-
does not exist under labor jurisprudence.
Mm.
It's an invention of the fertile mind of lawyers.
Yes.
Okay.
Nomenclature change.
So don't give me suspension of work. Okay. There's no suspension of work. There's either a strike or a lockout under the industrial law.
Disputes.
Yes, my lord, with the little
And
humble
you
bit of the law that I know, my lord, if I may just read out the definition of lockout, my lord, means
ID.
the temporary closing of a place of employment or the suspension of work. My lord,
Hmm.
I wasn't aware of all this earlier, but my
Hmm.
lord, because of the little stint, my lord, that I had, which I
Hmm.
regret, my lord, I learned these things. So, my lord, this was, my lord, so suspension of work, my lord, is recognized statutorily. It is, my
It's
lord,
not
equivalent
recognized
to.
statutorily. Sorry, no.
It, that's the definition which I read out.
It partakes, suspension of work is amounting to lockout only
Correct.
when the requirements of lockout are complied with under chapter code 4 na 6.
My lord, that's for a public
Industrial
utility
Disputes Act.
service. Correct. Section 22 onwards.
Ah.
My lord, if they have, my lord, complied with.
17, it starts from 17.
22, my lord, requirements are for a public utility service. My lord, thereafter, my lord, it is, my lord, where a notice is required.
So see
Otherwise, my
section
lord, there is.
23, compliance
Yes,
of
so
23.
correct. My lord, it doesn't, my lord, those bars of 23, etc., don't apply in this case. So I am, my lord, willing to justify it. But, my lord, I'm not going into that. I don't want to get into a contestation. My lord, your lordship put it to me today. Can I put in 50% of that? My lord, of that 2 crore claim.
Yes.
Now, my lord, your
So
lordship put me.
according to you that the company, the garden is on a lockout.
Yes,
according
my
to
lord,
you.
but my lord, your
So
lordships observe.
you will not go on paying the wages as of now.
No, my lord, may I, my lord? Your lordships, my lord, wanted, my lord, to hear from me with regard to 50%
Yes,
first for that
50%.
period.
You are
Yes, so my lord,
willing to pay 50% of.
without prejudice to my rights, my
Ah.
lord, your lordship, my lord, protects it and kindly gives me some time, which I leave to your lordship to put in that 50% for that, my lord, balance period, the lockout period. Third thing, my lord, your lordship kindly directs, my lord, conciliation officer to have, my lord, a meeting and settle the matter, my lord, within a time frame. That was why I came up before your lordships, my lord, that without, my lord, a conciliation, my lord, with the workman, it will become a problem. But I am willing, as it fell from your lordships, my lord, to put, my lord, 50% in, and your lordship, my lord, kindly, my lord, fixes a reasonable time for that. And my lord, the balance also 50, 50, 50, what I've said, my lord, I stand by it.
The first is there is an outstanding of 2 crore 41 lakh with regard to the period of abandonment.
Correct.
You are willing to pay 50% of that.
Your lordship asked me to, I have, my lord, your lordship wanted, your lordship indicated that, my lord, these are interim measures which will work, my lord, for the workman. So, my lord, kindly provide for it. I have no problem. My lord, I'll do it, but without prejudice to my rights, kindly, my lord, reserve that and kindly give me a reasonable time. I'm not even bargaining for that time, my lord. I leave it to your lordship.
And thereafter, what about the wages hereafter?
My lord, I'll pay. I'll pay, my lord, without prejudice to my rights, but kindly, my lord,
The
have the conciliation, my lord,
and other
directed.
wages have to be paid continuously
Yes. My lord, done, my
for
lord.
every
There is no-
succeeding month.
Yes.
Yes, my lord.
Then, my lord, may I understand in this way that first they will pay 27 lakhs present.
They will pay 2 crore 41 lakh 50%.
50% and 27 in the total.
They are already 27 lakhs they will
27
pay.
all
27 lakhs plus
half of the
1 crore 20 lakhs
lakhs
in respect of dues.
And the PF then 50%.
PF they will pay 76 lakhs.
Yes.
They will pay 60 lakhs with regard to
gratuity.
And
bonus.
And bonus they will pay.
They did not pay 2 years.
No, my lord, here, my lord, may I indicate? My lord, 32, my lord, your lordship has those instructions, my lord, which
No,
I think
first they,
were handed
32
up.
they have suggested 32 lakhs to be paid. So we will direct, they are saying July 2025, we will advance this date, subject to what they feel.
July.
No, I leave that. My lord, I am not bargaining on time. Your lordship wanted instructions, me to take instructions. I'm giving my lord,
So,
responses. Time I leave to your
what we
lordship,
propose
but
to
kindly
do
make
is,
it reasonable.
these first installments shall be paid within 7 days.
That 50% of the amount.
50%. Remainder shall be paid within a month thereof.
Lordship. And bonus is also 50% right now.
Bonus 32 lakhs.
Bonus 80 lakhs.
Remaining will not has not
Bonus is
accrued till date,
bonus is
according to that.
80 lakhs. Bonus is 80 lakhs.
You have said 80 lakhs.
Millard, I said 80 lakhs.
But it's 32 as per our calculation, my lord.
That 32 for the
40 lakhs they'll pay.
Yes.
As of now, they'll pay 40 lakhs
Yes.
in 2 installments.
Yes.
All right.
Yes.
What we propose is that 27 lakhs they pay.
Yes. Immediately.
PF they pay 70. What they undertook to pay?
74.6.
75 lakhs. All right.
Yes. 27 is plus. Yes. First component immediately. 27.
27 immediately.
Then half of the amount of the 2 crores, half of the amount of the 2
So
crores.
1.2 crores.
Yes.
And 75 lakhs as PF.
PF.
Gratuity, they are paying 67 lakhs there.
But the here is 1 crore 70 lakhs. Anyway.
Yes.
Mr. Mukherjee said.
Why you are shifting now?
So words of high responsibility. Let it fall from Mr. Mukherjee.
gratuity, they are willing to pay 70 lakhs. According to them, they are willing to pay 70. It is, they are willing to pay 70 lakhs, 67.17 lakhs. Gratuity. Let them pay these amounts in 2 installments.
Yes.
And the remainder shall be decided upon exchange of affidavits. Hmm. And Mr. Yes, now let us hear Mr. Prowal Mukherjee.
My lord, it was my instruction that, my lord, I was given possession.
No, are you willing to pay more than Mr. Mukherjee is paying?
My lord, I
Yes.
can pay 2 crores as of now.
Let him pay.
Yes,
If he
yes.
can,
Yes.
the corpus you have understood.
My lord, I have understood, my lord, but my lord, for the time being, since I'm a new entrant,
Right.
I have
Then
entered into a
you collect
bipartite
more money,
agreement.
Mr. Mukherjee. I mean,
Lordship.
Prabal Mukherjee.
My lord.
You are new entrant in the field. You grow. You grow. In the meantime, let Mr. Somendranath Mukherjee's client put in this amount, and after that, when you are powerful enough to outbid Mr. Somendranath Mukherjee, we will entertain your plea.
Lord,
All right.
it is, Lord, I tell you, Lordship, Lord, I am already
Show me
an
para 1 of the
experienced
order.
operator of the, I'm experienced operator of, Lord, the tea
All are
association.
experienced operators.
Now,
All
Lord,
experienced
what I
operators.
say
They
is that,
are
Lord, I have,
extremely experienced operators. The only problem is they believe in their operations only.
but
Yes.
may I just take an
Not the
instruction if I
operation for
can,
the
Lord, tell?
health of the garden, neither the operation, no garden runs at a profit. All right. So we don't know why people are so interested in holding on to failing businesses. Be that as it may, we are not economists, neither are we so well versed in commerce as senior counsels are. But what we can say is we require to protect statutory rights. To that extent, in an equitable jurisdiction, we are seeking to do so. In determining that, if a new person who has come in can match and put in further money in addition to what the appellant is undertaking or is in a position to pay, we would immediately entertain your plea. We
Yes,
will
Lord.
keep this issue open.
Yes.
Oh, within, Lord, 30 seconds, Lord, I'm giving my, Lord,
You
what my
give
client
your
says.
30-second response.
My lord, may I? Sorry.
Yes, Mr. Mukherjee.
My lord, only one thing, my lord, in
Yeah.
paragraph 1, my lord,
Yes, we
of
will
your
correct
lordship's order,
whatever
my lord.
you let us say. Just indicate, Mr. Mukherjee, where we have gone wrong. We will
My lord,
correct.
just the second sentence, the
Yes.
prompted the state respondents to initiate action. There
All
was
right.
nothing. That's been recorded, my lord, by the learned single judge.
Very good.
And
We will record your objection to this.
yes, and the second thing is, my lord, that we have this, my lord, so-called, my lord, standard operating procedure was produced, my lord, before the learned judge. My lord, our submission is recorded, my lord, that it has no sanction in law.
No sanction.
Because, my lord, it's in an occupied field and it
But
is not in exercise of any powers,
You
my
have
lord,
not,
of any act.
Mr. Mukherjee, you have not challenged it. We are not touching it. We are not
Yes, but
touching
it's
it.
recorded. It's recorded, my lord, in the order. They produced it that day. I have not separately challenged it because I had no idea how a third party is getting it.
Hmm.
My lord, page 4, kindly see the third paragraph. It starts from first paragraph. Paragraph 4, which it has been invoked in terms of the SOP.
May be relegated to LRTT.
Yes, my lord. Yes, because in the other round of litigation, my lord, which has been delegated to the LRTT, they went in appeal before the by way of, my lord, the 226, my lord, before the Honorable High Court, my lord.
We have understood. We have understood.
Yes.
Don't worry.
Yes.
And my submissions are, my lord,
Yes,
straight
your
after.
submission at page 5, particularly last line.
Correct.
That
I'm
it is
grateful. I'm
independent
grateful.
of the West Bengal Estate Acquisition.
Correct.
All right. So, Mr. Mukherjee, we record our order and dispose of
Yes,
the
yes,
appeal.
yes. And my lord, one thing, my lord, we make these payments. My lord, no third party, my lord, should be in the garden then or attempt.
No, no, you will,
My lord, we run.
we will say that you will be entitled to carry on the business.
I'm grateful, my lord. I'm grateful. I'm grateful. my lord.
Provided these compliance
Yes, my lord.
taking place.
Yes, yes, my lord. I'm grateful.
We are happy for the.
And Millard, we shall proceed in the NCLT. We don't
Really?
want to intervene.
Who stopped you, Mr. Jishu Chaudhary? Your fight will be inter-se fight, you fight it in the NCLT.
And we'll apply for intervention because we don't want the company's right to be prejudiced. We'll do that. We won't
That is
disturb
what we
your
are
lordship.
saying. We don't want this issue to also factor in your fight between the two
No,
groups
absolutely.
of management, right?
Absolutely.
That if you feel that you can persuade, you get the order from NCLT that you would be at liberty to run the tea garden or
Yes,
put in
yes.
additional funds, etc.
No, no, these are events which will help me in NCLT to get control of the company because this is obviously mismanagement.
Best wishes to you. Go ahead and do it.
Well, Mr. Prabal Mukherjee's 30 seconds, I think.
Lord, yes, I have taken instruction, Lord. My client says, Lord, I have taken instruction. My client says, Lord, he can put in, Lord, 2 crores. He has already put in 14 lakhs as of now, Lord, from 17th of January. And he says that, Lord, the condition of putting in 2 crores is, Lord, that the state should follow the SOP and, Lord, do what is needful to my client.
All right. We'll record your submission.
And Lord, there's another Lord submission, Lord, that the writ petition is not maintainable having regard to the prayers made therein. Your Lordship will kindly have a look
We
at
have,
the
we have, we have
page,
kept,
Lord, that.
we are not hearing the writ petition.
No, Lord, even Lord, for an interim order, Lord, I can take a point of
Have
them.
you challenged this order?
Lord, even if I don't challenge it, your
No,
Lordship,
sir.
sitting in
All
appeal can
right.
also
We have
see, Lord,
followed
whether
this.
the writ petition is maintainable or not.
Right. Good. Appellants have assailed. Appellant has assailed an interim arrangement. Oi. Appellant is the lessee of a tea garden named and styled as so and so. It is contended that the lease agreement is still subsisting. Due to encroachments by local goons and miscreants, there was indiscipline in the tea garden and the appellants were constrained to suspend work in the garden with effect from 19th August 2024. Matter was referred to the Labor Commissioner, District Labor Commissioner, who has not to initiate conciliatory proceeding, but no steps were taken. On the contrary, on 7th January 2025, a memorandum of understanding was executed between
17 January.
17 January, a memorandum of understanding was executed between 7th respondent and representatives of trade union, wherein they were permitted to enter the tea garden and
Run and to operate.
Permitted to run and operate the tea garden, subject to compliance of
Subject to payment of all.
Subject to compliance of the terms of the MOU, which inter alia included payments of outstanding dues. Being aggrieved, the appellants approached this court in this court seeking enforcement, inter alia seeking enforcement of the terms of the lease agreement entered into by and between itself and the state respondents and other reliefs. Upon hearing the parties, the Honorable Single Judge inter alia directed as follows. Set out the directions. Inter alia Honorable Single Judge inter alia directed that the issues may be that the case requires to be decided upon exchange of affidavits. As an interim measure, the Honorable Judge directed as follows. Page 7 থেকে page 8 এতটা। Mr. Mukherjee, Mr. S.N. Mukherjee contends that the appellants are ready and willing to deposit during at the time of on 28/1/2025. Now, in the course of hearing on 28/1/2025, this court directed the Additional Advocate General to communicate to the advocates on record of the appellant and the seventh respondent the total amount of outstanding dues of the workmen as on 17th January 2025. Appellant was also directed to disclose the manner in which they propose to liquidate the outstanding dues. Today, Mr. Chaudhary has placed on record the communication which discloses communication dated 28th January 2025, which discloses the dues as follows. Wages. A corrigendum has also been placed on record, which shows a sum of 2,14,50,000 as unpaid wages between 19/8/2024 to 17/1/2025. Mr. S.N. Mukherjee submits without prejudice to his rights, to his client's rights and contentions. They are ready and willing to deposit a sum of rupees they are ready and willing to deposit
27 lakhs first.
Deposit as follows.
Yes.
Rupees 27 lakhs
For the
wages, for
fortnight
due wages up to
for 4 fortnight wages.
Fortnightly wages.
Up to 19/8 to 27 lakh as follows. 27 due wages for 4 fortnights up to এইভাবে করো, তিনটে চার্ট করবে, বাঁদিকের চার্টটা আউটস্ট্যান্ডিং ডিউস, প্রথম দেবে ডিউ ওয়েজেস আপ টু 19/8/2000, হ্যাঁ, স্টেট ক্লেম 27 lakhs, appellants undertaking 27 lakhs within 7 days. Outstanding wages
2 crore 14 lakhs 50,000.
2 crore 14 outstanding wages during abandonment 19/8/2024 to 17/1/2024. State as a claim 2 crore 14 lakh 50,000.
Well, that will be 25. 2025.
25.
Seven-
Appellant's undertaking 1 crore 20 lakhs within 7 days. Date ta debe. Remaining amount to be paid the remaining amount shall be paid subject to the result of the within 7 days they will pay 1 crore.
Half of the amount. And half of the amount within a period of 1 month, my lord, they say. This amount at least.
That probably Mr. Mukherjee has not consented to because that is disputed.
my lord,
Because for that period, no one had worked in the garden.
So
So your lordship has
you
said
have not
half
allowed
of the amount. Half of the wages we
half
have
of
to
the
pay. as of
wages
now.
you pay.
Their
Yes.
wages.
Remaining wages shall be paid upon during at the time of hearing of the final
Right.
petition.
my lord, then they will be, my lord, this period. My lord, if the respondent number 7 is ready to pay 2 crores. My lord, kindly say for a
2 crores
hypothetical.
for what? What
For
about
40
provident fund?
No, my lord. I think so.
That will be covered by the MOU, Lord. I am going by
But
the
the
MOU.
wages,
The
wages.
MOU takes care of that.
They are ready to pay.
What is the MOU saying about that?
Lord, I'll tell you, Lordship. Lord, that says, Lord, that the
And
guardian,
what is-
Lord,
what is the-
memorandum of understanding can be handed over to your Lordship by my junior there. That the garden will reopen on 17th. The management will disburse the due wages of last fortnight month.
All right, the remainder amount shall be paid within 3 months.
Yes, my lord. Yes.
This 2 crore.
Yes, yes.
Within 3 months.
What is 2 crores 40, whatever.
Yes. The remainder amount
Yes.
will be paid within 3 months. Then provident fund dues, state claim 1.40 crore. The 75 lakhs shall be paid
Till 2024, July 2024.
till July 2024. 75 lakhs shall be paid within 1 month. All right?
Not any 7 days, my lord. PF.
Yes. All right, let us keep it. Let them give some breathing time
That's
also.
in 2 installments.
No, we are
Immediately
giving with, then you pay 50% within 7 days, remainder within 1 month.
Yes, that's what I'm saying.
So in 2 installments,
Yes,
first installment shall be paid within 15 days and the other installment
within 1 month.
Rest 15 days.
remain
Remaining 15 days.
another 15
It
days.
means 75 lakhs.
We'll give the dates. The remaining amount, Provident Fund Commissioner, now with regard to the outstanding amount, Provident Fund Commissioner shall submit report with regard to outstanding dues.
As on 17th January.
Outstanding dues as on 17th January 2025
Therefore,
before the learned single judge, who shall be at liberty to pass further orders with regard to such payments upon hearing the appellant and other respondents, upon hearing the parties concerned. Gratuity dues, state claim is 1.7 crore, appellant's undertaking.
my lord, here kindly a rider, my lord, because they did not disclose by a form L. So let them disclose by a form L.
We will give those directions we will give after this
My
chart. Appellant's dues, appellant undertaking হচ্ছে 70 lakhs within 7 days. Appellants shall submit reports under form L
Yes.
of the West Bengal under the
gratuity act.
If I may propose this, let
Gratuity
the
Act
controller of
90.
gratuity inspect our records in the garden itself within a week. and ascertain the dues. Let
Well,
us
you are now, you will be
It is
running the
your
garden.
obligation.
No, no,
Declare
we
ill.
will do it. Whatever is our obligation, they can also inspect.
No,
So that
you
we
will,
can come to a common.
requisite form L
L.
with under
Under the Gratuity Act of 19.
Payment of gratuity
72.
rules, maybe.
under the relevant act shall be furnished before the controller
Yes.
within a fortnight from date.
Yes.
Controller shall also be at liberty to inspect the records of the appellant for determination, records of the appellant and direct the
And to furnish a report.
and submit report before this court with regard to outstanding, if any, after payment of the
70 lakhs.
aforesaid sum. এগুলো কিন্তু ওই চারটার পরে প্যারাগ্রাফ করে আসবে, বুঝলে? Next, bonus.
So, Milord, if I may just, sorry for the interjection, Milord. This Form L, which is our obligation to submit, only comes when a notice, the persons, the employees who have retired, only when they pray for an application that I am entitled to gratuity, pay this under Rule 7. Then only our obligation to issue Rule 7 comes.
We will ask the controller to submit report.
Yes.
With regard to statutory compliances.
Right.
Upon examination and also indicate the outstanding amount.
Correct. So
payable after in over and above the amount that you are presently depositing.
Absolutely. So the Form L, Milord, kindly, Milord, let us ignore that for the time being. Yes.
Bonus state claim is 80 lakhs. The appellant undertakes to pay 80 lakhs as on
20 for the year 2023 and 2024.
For the years 2023 and
During Puja bonus.
2024, the appellant shall undertakes to pay a sum of rupees 40 lakhs within a month.
Week, my lord. This bonus can be paid week because they did not get for
everything with
no, about 15 months.
Within a month.
I leave it to lordships.
Within a month.
Milord, in our proposal, we have paid time till July for the bonus.
The remainder shall be paid within 40 now, another 40 in another month.
Milord, that accrues as payable in October 2025. The remaining, Milord,
No, that is with regard to 25 bonus.
No,
This is 23 and 24.
25 bonus will come.
Milord, even 24 probably, Milord, it accrues on October.
No, sir.
No.
It accrues on 24 October.
Not a financial year.
Who gives the puja bonus you give after next year puja?
No, Milord, at least, Milord, since these are the areas, we
Ah.
kindly have a breathing
You
space.
did not
Milord.
pay.
We are giving you breathing space, 1 month and another month, the next 40 lakhs.
Right.
2 months.
Right.
Full stop. তারপরে ওই the controller will give the report and Provident Fund Commissioner will give the report. Full stop. Mr. Probal Mukherjee, for the 7th respondent's offer to deposit, submit that his client has already paid a sum of rupees 14 lakhs so and so in terms of the memorandum of understanding and offers to deposit a sum of rupees 2 crores with regard to outstanding wages. In view of the fact, we take note of this submission. His client is at liberty to make a better offer than the appellant with regard to liquidation of dues before the trial court. In the event he does so, the trial before the Honorable Single Judge. In the event he does so, the Honorable Judge may pass appropriate order on such prayer as on such prayer in a on such prayer. Full stop. In the event the appellants deposit the aforesaid sums in accordance with, as undertaken by them before this court. They shall be permitted to run the tea garden as per law.
After a month, because they will pay what they say undertaken, the 1 crore 20, half of the.
We are making it clear, they shall be permitted to run the tea garden in accordance with law and subject to payment of wages, current wages and compliance of other statutory dues. And other statutory obligations in respect of the workmen. In the event they fail to deposit any one of the aforesaid installments within the stipulated time, the interim order shall stand vacated and the state authorities shall be at liberty to take appropriate steps for resumption of the garden in accordance with law.
Grateful, madam.
All right?
Grateful, madam. You have protected me in all aspects.
In accordance with law. Full stop. The payments, needless to mention, the undertaking as well as the payments made by the appellants are without prejudice to their rights and contentions in the present proceeding as well as in collateral proceedings. Full stop. With these, the appeal is accordingly disposed of, affidavits not being called for, allegations are not.
The direction
Just two things, my lord.
Direction of to exchange the affidavit as directed by the Honorable Singhil Judge, that will remain, or my lord, your lordship is extending?
So it's remaining, if you
Because
want
if they do not pay, because the time period was, my lord, within the 15th February, something like that. And
No, fifth they have to file affidavits.
So affidavit is, Mr. Probal Mukherjee is saying that this is not maintained.
No, that is what my submission is, my lord. It is not maintainable because of the prayers that they have made in the.
That is your
My lord, may I
submission,
make-
isn't it?
Yes. They are asking for, my lord, a determination of, my lord, a leasehold interest.
My lord, may I, my
Mukherjee,
lord?
one of the prayer is enforcement of an agreement with the state.
Lord,
To that
in
extent,
my respectful submission, my lord,
an arbitrary resumption is always amenable to the riches.
but without a challenge thrown to the SOP as well as, my lord, the
Forget the SOP.
notification.
Forget the SOP.
Because in the other matter where I
No,
appear,
sir, we are not deciding that issue, so let us not deliberate on it.
I just inform you, my lord. in
Yes, you
other
have
matter where-
informed, we have taken into consideration that issue.
My lord, may I, my lord, just, my lord, seek one indulgence? My lord, your lordships had noted, my lord, that what is stated, my lord, in yesterday's order, para 1, that I am disputing that your lordship put, my lord.
Sir,
kindly, my lord.
we have supervened that order with our.
Very
That
well,
is
my
why
lord.
I took the trouble
I'm
of
grateful.
dictating
I'm
it
grateful.
from your pleadings.
I'm grateful, my lord. And the second, my lord, is, my lord, that once we start making this payment, my lord, from day one, my lord, the district magistrate and the superintendent of police should ensure, my lord, that no third parties, my lord, get into the picture.
We are making it clear, all parties shall act in accordance with the direction
Oblige
passed
your
by
lordship.
this court.
Yes.
I'm grateful.
Grateful, madam.
Much obliged, my lord.
May I get back the book, madam?
Which book?
These two books. One is gratuity.
No, that controller thing, please give that. Who is to give the report?
Report controller. I will give you the exact, my lord, his
Name.
designation.
Section
Right.
7.
Right. Thank you, Mr. Mukherjee.
I'm grateful, my lord.
Thank you.
Assistant Labor Commissioner.
Yes, sir, that death reference,
But there
keep it tomorrow. We'll keep it tomorrow if we can take it up. At 2 p.m. we'll keep it, right? Because tomorrow we don't think we have got much matters. So today we had a few heavy matters.
Tomorrow lordship also having the single
Have
bench matter.
Oh, ঠিক আছে, পরে আমি নিয়ে নেব।
Single bench we will take up. Single bench will take up at
পরে দেব।
let us see. We'll try to take both. Single bench, so you will, you're prepared, where is Laksam? He has left. So tell him, prepare a note.
Yes.
So that you put in your notes, we make it see. Can you talk to him? Can't.
4:10 today. Lordship. Get for the mark.